For judgment, item number 49.
May I please your lordship?
Just a minute. Huh? As a result, the judgment and award dated 19/10/2020 passed by the London Member Motor Accident Claim Tribunal, Dimapur, Nagaland, in MSC case number 15/2015 is hereby set aside. So far as the direction of the tribunal to the owner of the vehicle, respondent number 1, in MSC case number 15/2015 to pay the awarded amount to the claimant within 3 months from the date of passing of the. Further, I'm of the opinion that the interest of justice will be subserved if the respondent hearing the insurance company is directed to satisfy the awarded amount in favor of the appellant claimant and recover the same from the owner of the vehicle. With the above observation, this appeal stands allowed to the extent aforementioned and disposed of. No cost.
May I please move?
Yes.
Lordship, item number 4. Lordship, when was 3 weeks after the vacation to obtain instruction, Lordship, I've taken the consent.
Okay. So you are for a petitioner.
Lordship.
10 December. 10 December.
Mr. Angami,
10 year over to 9
appealing on behalf of the respondent with the consent of the London Council for the petitioner prays for listing this matter after
Vacation, Lordship.
vacation. The prayer is allowed. List this matter after the ensuing vacation. Okay.
Lordship.
Lordship, item 43, hearing item 43. May I pray this matter will list after vacation.
After
After vacation.
criminal petition, is there a respondent here? Private? Okay, no objection.
No.
Okay. Mr. L. Iralo, London Council for the petitioner, prays for listing this matter after vacation. The prayer not objected to by the London Council for the respondent. Accordingly, the prayer is allowed. List this matter after the vacation.
May I pray for the same order with in regard to item 27 also?
1827.
Yes.
Okay, similar order. Huh?
I'm okay.
Lordship, I have another prayer, item number 6, Lordship.
Item 6.
Immediate receive instructions, so can you grant me releasing the matter after vacation, Lordship? I've taken the consent, even this.
Okay. Okay, Mr. Angami, London Council for the respondent. You are for respondent number?
Lordship.
All respondent.
Yes.
Okay, respondents with the consent of the London Council for the petitioner. Praise for after vacation.
Lordship.
Listing this matter after vacation. The prayer is allowed. List this matter after the ensuing vacation. Okay.
Lordship.
May I please your lordship?
Yes.
Lordship, I beg to mention item 38, your lordship, for adjournment.
38.
Yes, your lordship. The engaged counsel is nothing from figure, your lordship.
You are for the petitioner.
Yes, your lordship, for the petitioner.
Okay,
Lordship, the matter may be listed on date 10, your lordship.
on,
On date 10th of December, your lordship.
yes, respondent. Yangarwati.
Your Lordship, I'm appearing on behalf of my senior CJC, Mr. Yangarwati.
Okay, no objection. Okay,
Oblige, your lordship.
your miss,
Your lordship, P Talk BP.
okay, you are appearing on behalf of NK More.
Yes, your lordship.
PW. Your good name?
Your lordship, P Talk BP, your lordship. Talk BP, TOKBIPI, your lordship.
Okay, appearing on behalf of Mr. NK More. Land
Yes,
Council. Praise for listing this matter on 10/12/2024, to which the Land Council appearing on behalf of the respondent has no objection. Prayer allowed. List it accordingly. Okay.
Oblige, your lordship.
My His Lordship, my
Yes.
lord, I beg to mention item number 15. My lord, here I'm yet to receive instruction. So can I allow me 3 weeks time?
Item
15.
Okay, but the petitioner is also present. Waling Supamwati. Have you informed the petitioner?
No, my lord. I
Then
could not.
Hmm?
I could not. However,
is-
I have not received instruction, my lord.
but then his presence may be have to be recorded. Whether he is present, you have to inform.
My
Inform
lord, I'm
first.
informed that he's out of station. I'll
He's out of
inform him, yes.
Okay. Okay. Mr. Jimomi. Oh, sorry.
Itibapum.
Itibapom. Land Council appearing on behalf of the state respondent. Prays for further
3 weeks time.
3 weeks time to obtain instruction and to file affidavit in opposition. He has also that he submits that the Land Council for the petitioner is also out of station. In view of the above, the case stand adjourned. List this matter after 3 weeks. Okay.
Much obliged.
Yes.
I beg to mention item number 28,
To 8.
item number 28.
20.
28. Lordship, we have instruction to appear on behalf of the respondent. So I'll be filing my Bagalama during the course of the day.
Okay.
Kindly grant 4 weeks time to file our affidavit in opposition.
Mr. L. Iralu, Land Council for the petitioner is present. Mr.
CD rules.
Would appear on behalf of the respondent number?
Full response.
Okay, so appear on behalf of the sole respondent and prays for some time to file wakalatnama
We'll
and,
be filing our Bagalama during the course of the day.
okay, and submits that he will be filing wakalatnama during the course of the day and prays for some time to file
Affidavit in opposition.
affidavit in opposition. If so advised, stop.
Your Lordship,
Prayer allowed,
may I
list
also
this
be-
matter after
4 weeks, Lordship.
4 weeks.
Okay.
Okay,
Yes, may I also be allowed to file one additional affidavit just to enclose an
additional affidavit.
Yes.
Then in that case, you have to first file additional affidavit, then thereafter only they can file reply.
Yes, very well.
Okay. Then in after Eli Ralu, Land Council, Mr. Eli Ralu, Land Council for the petitioner, who prays for allowing him to file additional affidavit. Then thereafter he's okay.
There's an interim if that may be
There is
continued.
interim para last. The interim order passed earlier shall continue to the next date.
I'm all right.
Okay.
Duly obliged.
May I please, Your Lordship? I'd like
Yes.
to mention item 40 from the hearing list, Your Lordship.
40.
40, Your Lordship. This matter may be listed after vacation, Your Lordship. Here, the similar matter is pending before the Supreme Court, Your Lordship, so it may be listed after the vacation.
Okay, you are for the petitioner,
Yes, my lord.
Miss.
Kamungla Longkomer. My name is not reflected in the court list. I'm
Okay.
appearing on behalf of my
Appear on
firm.
behalf of Mr. Imti Longchair, Land Council for the petitioner. Stop. Miss, her name. Land, you are
For the state, Your Lordship,
okay.
in a holy.
Appearing on behalf of Miss Ina, you're Ina Holly,
Yes, Your Lordship.
okay. Stay, appearing on behalf of this respondent. Praise for
After vacation, Your Lordship.
listing this matter after vacation, prayer not objected, stop. Accordingly, the prayer allowed. List it according, list the matter after the entering After 4 weeks
Yes,
or vacation?
after 4 weeks.
Okay, after 4 weeks. Okay.
Your Lordship, I also praying on behalf of my colleague for item 16, Your Lordship. On behalf of AIM, item 16 here, she's yet to receive instructions. So kindly
Okay.
grant 3 weeks time to receive
Mr. Nadi?
instructions. To file.
Santiago is present. Have
Yes, Your
you?
Lordship.
Okay, you are Miss?
Viteri.
Okay, Learned Counsel for the petitioner is present. Stop Miss Inalve, appearing on behalf of the said respondent. Submits that she is yet to receive instruction and prays for some more time. Prayer allowed. List is matter after 3 weeks.
2 weeks.
Okay.
Your Lordship, item 19 as well, same prayer, Lordship. Item 19,
19 also.
yes, Your Lordship.
Anyone appearing? Have you informed the petitioner?
No,
Lordship. I'm for the
Okay.
petitioner.
You are Miss?
Berta Tep.
Learned Counsel for the petitioner is present. Miss Inalve, appearing on behalf of. Here also instruction. You have not yet received instruction or
Yes,
what?
Your Lordship.
Okay. Submits that she is yet to receive instruction and prays for some more time. Prayer allowed. List is matter after 3 weeks. Okay.
Much obliged.
May I please, Your Lordship?
Yes.
Lordship, I'd like to mention item number 5, Your Lordship. On behalf of Dr. Ankit Tori, Your Lordship. Lordship, if this matter can come up after vacation, Your Lordship. I've taken the consent from the other party.
Okay, Mr. Medabiro, Learned Counsel for the petitioner with the consent of the other side, prays for listing this matter after
Vacation, Your Lordship.
the ensuing vacation. Prayer is allowed. List this matter after
Vacation.
the ensuing vacation.
No objection.
Okay, you are Mr.
Oh, is that cool?
Okay, Judge Kuri, Learned Counsel for the petitioner is also
Oh.
present.
For the respondents.
Oh, sorry, for the respondent is also present. Okay,
Possibly prayer for item number 35, Your Lordship.
35.
Your Lordship. I've taken the consent from the other party as well, Your Lordship.
Okay. Mr. Medabiro,
Lordship.
Learned Counsel for the petitioner with the consent of the other side, prays for listing this matter after 4 weeks. The prayer is allowed. List this matter after 4 weeks.
Lordship. Lordship, I have similar prayer for item number 42, Your Lordship, on behalf of Vikram Devnath, who is on bereavement, Your Lordship.
Hmm?
On behalf of Vikram Devnath, item number 42. If this matter may come up
Okay,
after vacation.
whether the other side present?
He has taken the consent from the other party.
Okay, Mr. Medabiro, appearing on behalf of Mr. V. Devnath, Learned Counsel for the appellant, with the consent of the Learned Counsel for the other side, prays for listing this matter after
Vacation, Your Lordship.
4 weeks. Prayer is allowed. List this matter after 4 weeks. Okay.
Lordship, I have similar prayer for item number 44, 45, and 46, Your Lordship. Analogous
44,
matter.
45.
Yes, 44, 45, and 46. Lordship, I've been informed by the petitioner that they will be engaging a senior counsel from Nagaland itself. So some time may be granted, Your Lordship.
Please, Your Lordship.
Yes.
Lordship, in this case, Your Lordship, there is a criminal appeal pending before the session judge, Your Lordship. Now, if that appeal is succeeds, Your Lordship, this matter will become infructuous, Lordship. So if these matters may be listed after disposal of the criminal appeal, Lordship.
This criminal petition is the quashing petition or what?
Lordship.
Okay. So appeal is pending.
Yes, Your Lordship. Criminal appeal number 1 of 23 before session judge Dimapur, Your Lordship.
23.
Yes, Your Lordship. Criminal appeal number 1 of 23.
You have an idea about that?
I was informed, Lordship.
Hmm?
I was informed regarding that, but
Okay.
I do not have the petition.
Then it has to, if the appeal is pending, then it has to be after the appeal is disposed of.
Yes, Your Lordship.
No, such instruction, Your Lordship. If this matter may come up after vacation only, Your Lordship.
Because if that succeeds, Your Lordship, this matter will become infructuous, Your Lordship. So
But the appeal has been heard, not yet.
not yet, Your Lordship.
Okay, Mr. Medovero, Learned Counsel for the Learned Counsel.
For petitioner.
Your name is there? No.
Lordship.
Okay. Learned Counsel for the petitioner is present. Stop. Miss
Esther, Your Lordship.
Esther, Learned Counsel, appearing on behalf of the respondent.
1, Your Lordship.
Number 1, submits that who has filed appeal?
I file, Lordship.
Okay. The respondent has filed criminal appeal against against
Against the order passed by the CGM, Your Lordship, 7/12/21.
okay, against the order passed by the Chief Judicial Magistrate
Yes, Your Lordship.
on 7/12/21,
7/12/21.
and hence pray for listing this matter after the disposal of the said appeal. In view of the above, list this matter after the disposal of the appeal. The respondent shall inform this court accordingly. Okay,
There's an interim, Your Lordship.
what is
In-
the intent?
In
Because appeal is,
Okay,
appeal is pending there,
Your Lordship.
appeal filed. Okay,
Okay, oh, plus one.
Yeah, please, Your Lordship, I'd like to mention item number 41.
41.
Let the matter come out after vacation on
After
behalf of Income Jamia.
Okay, so what about the other side?
Lordship. I have no objection.
Okay, Mr.
Nang Sanaya on behalf of Income Jamia.
Land Council appearing on behalf of Mr. Imkong Zamir, Land Council for the appellant. Praise for listing this matter after
Vacation.
vacation, to which Mr. Medaviro, Land Council for the respondent has no objection. Prayer allowed. List this matter after the ensuing vacation. Okay.
May be obliged.
Your Lordship, I beg to mention item 14. I pray for 3 weeks to file my affidavit.
1-4.
Yes, Your Lordship. 14. I've taken the consent of the petitioners. Your Lordship.
Okay, Mr.
M. Longkumar.
Land Council, Land
State.
Government Advocate
Yes.
appearing on behalf of the state respondent.
Next.
Praise for further 3 weeks' time to file affidavit.
Yes, Your Lordship. Affidavit in opposition.
Affidavit in opposition. He has also informed the Land Council for the petition, oh, sorry, no, for the petitioner. He is prayed for come list this matter after 3
3
weeks.
weeks, Your Lordship.
Okay,
Lordship, I have a similar prayer for item 22.
here also you are appearing.
Yes, Your Lordship.
Okay. So, Mr. Watijam,
Yes.
okay. Mr. Watijam, Land Council for the petitioner is present. And then his name, Mr. appearing on behalf of the state respondent. Prays for further 3 weeks' time to file affidavit in opposition. The prayer is allowed. List this matter after
3 weeks.
3 weeks. Okay.
There's an interim order, Lordship.
Para. The interim order passed earlier shall continue till the next date. Okay.
Obliged, Your Lordship.
Yes.
No, I think number 23, for respondent.
Item 23.
23. I'm making 3 weeks time to file my contract. I informed that.
Item 23. Mr. Limawapam, Land Council for the respondent,
Respondent number 5.
number 5, with the consent of the Land Council for the petitioner.
I informed the council president.
Oh, you have informed?
Yes.
Okay. So when do you want?
After 3 weeks.
Praise for the 3 weeks time for what?
For filing my contract.
Okay. Further 3 weeks time to file his counter affidavit. His counter, the prayer is allowed. List this matter after 3 weeks. Okay.
Yeah, please, Your Lordship.
Yes,
Lordship, item number 17.
yes.
Lordship, since I have sent to obtain the signature, so kindly let this matter come up after vacation.
Okay, Mr. Watijami, Land Council for the petitioner is present, and Mr. Achungli, Land Government Advocate. Senior government,
No.
okay, senior government advocate submits that he has sent the affidavit prepared for affidavit for obtaining signature of the officers and prays for further time. 4 weeks time. Why for 3 weeks time? Okay, 3 weeks times. Okay, the prayer is allowed. List this matter after 3 weeks. Automatically that will be after vacation only. Okay.
Yes, Your Lordship.
Yes.
I beg to mention item number 29.
29.
Yes, Your Lordship. I'm appearing on behalf of respondent number 2, 3, and 4.
So
Kindly allow us 3 weeks time to file.
you
our
are for
affidavit in
respondent.
opposition.
Who
Yes,
is for the
Your
petition?
I'm for the petitioner.
Okay. 3 weeks time for?
To file our affidavit in the position.
Okay. Mr. L. Iralo, learned counsel for the petitioner is present. Miss, you are Miss?
PILIE.
Learned counsel appearing on behalf of the private respondent number 2, 3, and 4. Prays for 3 weeks time to file affidavit in opposition. Mr. Tibapong, learned counsel for the state respondent is also present. He is prayed for, list this matter after 3 weeks.
May I please, Your Lordship, I beg to mention item number 18. Your Lordship, I'm appearing on the instruction of my senior counsel for the petitioner. The pleadings are completed, so kindly fix the date for hearing on 9 December. The parties have agreed.
You are for the petitioner.
Yes, Your Lordship.
You are Miss
Abi,
Abi.
yes.
Your name is there? No.
No,
Appearing on behalf of
Nityo Gozo.
Nito Goza. Okay.
Yes, Your Lordship.
Appearing on behalf of Ms. Nito Goza, learned counsel for the petitioner submits that the pleadings is completed in this case and pray for and listing this matter for
9 December
9 December for what?
hearing.
What is this matter about?
Your Lordship, promotion.
Okay. 9 December for hearing. Okay. The prayer is allowed. List this matter.
Your Lordship, there's an interim order. Please let it continue.
We may have to see. This is in the admission stage. Where is the state? Who appears on behalf of the state? Okay. Item 18, just once. No. Is there any private respondent also here in this case? No.
Your Lordship.
The prayer is allowed. List this matter on 9th. Is prayed for, list this matter on 9th for hearing. Okay.
Yes, okay.
Interim is there. What is the interim? Okay, the interim order passed earlier, shall continue till the next date. Okay.
Please, Your Lordship,
Yes,
may I please mention hearing item number 36 and 37. Your Lordship, if this matter can come up the vacation.
the petitioner is present. Okay, you are Mr.
Manchong Konyak.
Land counsel for the petitioner is present. Miss
Livika, Your Lordship.
Libika. Land counsel appearing on behalf of the state respondent. Pray for?
After vacation, Your Lordship.
Okay. Prays for adjournment of the matter. For 3 weeks. Prayer is allowed. List this matter after 3 weeks. Okay.
Your Lordship, I also beg to mention item number 33 and 34. 33, 34. Your Lordship, in this matter, like, we are supposed to get a report from the district court, Your Lordship. So whether that report has come or not, Your Lordship, and if that report has not come, if this matter can come after vacation.
Okay, just 33. We received the report. Report from where?
Magistrate, your lordship.
In,
Inquiry report
in
is-
writ petition?
Yes, your lordship. There's an inquiry, your lordship.
Okay.
This honorable court has given a direction for an inquiry by the magistrate, your lordship.
Okay. Item 33, please. Hello. Item 33. Whether the report from
Yes.
report received.
Yes.
Your lordship, if the report has been received, then the copy may be furnished to both the
Then
petitioner.
let us see whether a copy can be furnished. No, it is in the seal cover. That
Your
cannot
lordship,
be
then let
furnished
it come after vacation. your lordship.
after vacation. Who is for the respondent? You are for respondent. So who is for the
Respondent and
petitioner? Okay,
On behalf of IMT launcher.
okay, so it will be listed after vacation.
Yes, lordship.
Okay, yeah, Miss
Kamungla Longcomer lordship.
Kumar. Appear on behalf of IMT Launcher. Okay, Miss Livika, Lana Council appearing on behalf of the state respondent. Okay, the inquiry, just a minute. The inquiry report was ordered by which date? Order of which date? Okay. The inquiry report as directed by this court on 4/6/2024 has been received from the court of the principal district and session judge Kohima, Nagaland. So it's prayed for by the Lana Council for the
Lordship,
respondent.
let it be a consensus prayer.
Hmm?
Consensus prayer, your lordship. Both the council, your lordship.
Okay, it's prayed for by both the Lana Council for the parties. List this matter after the ensuing vacation. Okay,
Oblige lordship.
May I please, your lordship?
yes,
May I mention item number 30? I have a consent from the other side.
Item?
30, I have consent from the other side. Lordship, may kindly allow me 3 weeks time. Item number 30.
both the Lana Council for the petition and miss. You are for,
For the state lordship.
okay, you are
For
for,
private respondent, number 4.
okay, you got. Mhm. So the petitioner is not present otherwise, you have taken consent, okay. You are miss,
Kim Piana.
Lana Council for the petitioner is present, you are Mr.
James Newman.
Okay, and our name, huh? Are present, huh? You are for respondent number
4, private respondent.
four are present, as prayed for by the Lana Council for the parties. List this matter after
3 weeks.
3 weeks. Okay.
Lordship, may kindly direct the registry to reflect my senior's name. His name is not being reflected in court.
What is your senior name?
Taka Kichu.
Okay,
We have filed our vakalat.
Mr. The name of Mr. Takakichu, Lana Senior Government, Lana Senior Advocate may be reflected as the Lana Council for the respondent number
4.
4 in the course list. Okay,
Much obliged.
This lordship.
yes,
I beg to mention item number 12 on behalf of S check. Here, the state is still received instructions, so kindly grant 3 weeks time.
item 2,
12 lordship.
12.
No lordship.
I don't have any objection. lordship.
Hmm?
I don't have any objection.
Okay. You are Mr. Tosi,
Substitution.
Tosi Tamzin, Wong Lana Council for the petitioner is present. Miss,
On behalf of S Chang lordship.
okay, appearing on behalf of S.
S Chang.
Okay, S. Chang, Lana Council for the state respondent Prays for listing this matter after
3 weeks.
3 weeks. Prayer allowed, list this matter after 3 weeks.
Lordship, same prayer with item number 20.
20.
Lordship.
You are for the petitioner.
Yes, your lordship.
Okay. Your name, Miss?
Sigma.
Land counsel for the petitioner is present. Okay. And same, huh? Miss appearing on behalf of
Extra.
S. Chang, Land counsel, Land State Counsel for the state respondent. Prays for listing this matter after
3 weeks.
3 weeks. Prayer allowed, list this matter after 3 weeks. Okay.
Lordship, similar prayer with item number 21 also.
21.
Lordship.
Okay. Same order.
23 also, Lordship.
23
On
already
behalf of
adjourned.
Extra. Okay. Okay,
Mm.
Lordship. Then Lordship, I also like to mention item number 24. Here I need to receive instructions, so kindly grant me 3 weeks time.
Okay. You are Mr.
Manjong Konyak.
Land counsel for the petitioner is present. And Miss
Pitch off.
Land counsel, Land government advocate for the state respondent. Submits that she is yet to receive instruction to file affidavit in opposition. And prays for some more time. The prayer is allowed. List this matter after 3 weeks. Okay.
I pledge.
May I please your lordship? Lordship, I beg to mention item number 7, lordship. Lordship, if this matter can come up on the 10th of December, lordship.
Okay.
I've taken the consent of the
You are for
the petitioner, lordship.
petitioner. Miss Mika and Land counsel for the petitioner with the consent of, you are here for?
For the respondent, sole respondent.
Okay. Praise for listing this matter after.
10th of December, lordship.
Okay, listing this matter on 10th of December to which Mr.
Kohima.
Kohima, the Land counsel for the respondent has no objection. Is prayed for, list this matter on 10th December. Okay.
Lordship.
My apologies, Your Lordship. Lordship, but I've already mentioned item number 5 and 35, Lordship. Item number 5 as well as 35. There's interim in both the cases, Your Lordship. So if the interim may be continued, Lordship.
In item 5,
Item 5 as well as item number 35.
5, the interim order passed earlier shall continue till the next 5. 5 taken by
5 as well as 35. Item
5 and
35,
35.
Lordship.
35 also adjourned.
Yes, it was
There
adjourned,
is
Lordship.
interim. Okay.
Okay. Much obliged, Your Lordship.
Yes.
I'd like to mention item number 3. I've read this letter can be after the vacation.
After vacation. Okay, you have filed affidavit? No, not yet.
I filed.
Already filed.
I put a respondent number 2.
2. State has filed.
It's a complication, my lord. Content.
State, sorry, no, sorry. And you are for 2, and you are for
Everything.
3. 3 filed?
No,
Not yet. And
Yeah.
there are other respondent also. Are you are for?
I will be the respondent number 1.
1. Okay, Mr. You are Mr.
Abel, I am, Your Lordship.
And counsel for the petitioner is present, staff. Whether 1 has filed affidavit?
No, no.
Not yet.
No. I have filed long time back.
Long time back. 3 not yet filed.
not yet filed.
You are paying for some time.
Lordship, here we have a communication between the respondent number 2 and 3. So,
Respondent number 3 is the newly implemented respondent.
Yes,
The respondent number 3 is newly impleaded.
yes.
You want to file affidavit also?
Yes.
Okay. Mr. Moa Imchan, National Government Advocate, appear on behalf of the respondent number 1. Mr. Land Council, sorry, appear for the respondent number 2 and Mr. Okay, team so for respondent number 3. So 1 and 2 already filed, 3 not yet filed. Who submits that? Is the respondent number 3 is newly impleaded in the instant contempt petition and prays for some more time to file affidavit in opposition. Affidavit. You want to file?
Yeah, compliance affidavit.
Okay, compliance affidavit. Okay, praise for some time to file compliance affidavit. The prayer is allowed. List is matter after 3 weeks. Okay.
Application.
After it's all the same. Okay.
May I please, Your Lordship? I
Yes.
may be allowed to mention item 30
Item
for the
30.
petitioner. Here the notice is completed.
It's in order column. Let us see the record. Okay, and pass order. Wait for some time. Yeah.
I filed the
You have already filed affidavit. Affidavit of opposition you have filed.
complete, yes. This morning
Fine, okay. Then it will be listed for. What is your submission, you said,
I may be allowed 4 weeks time to file my reply.
or reply?
Yeah. And as per this honorable court order dated 37/24, respondent notice upon respondent 5 to be given in abeyance until further notice.
Respondent number 5
Yes.
appeared.
No, in abeyance. So the notice upon respondent number 5 to be given in abeyance.
What happened to respondent number 5?
This honorable court have observed that the affidavit filed by other respondent is enough
Okay,
in this case.
and you are for respondent number?
1, 2, 3, 4, 6, and 7.
Okay, so for 5 it will cover.
Yes, until further notice.
Okay. Mr. Pakim Rijabo, learned counsel for the petitioner, wants to file affidavit in reply to the affidavit filed by the respondent number 1 to 4,
1, 2, 3, 4,
6, and
7.
1, 2, 3, 4, 6, and 7. And prays for some time. The prayer is allowed. List is met after.
The 4 weeks month.
After. Okay, 3 weeks. Okay.
Hello, Blackburn.
Wait, please, Your Lordship.
Yes.
Your Lordship, I beg to mention here in item number 39.
29,
39.
39.
Yes, Your Lordship. Your Lordship, I'm mentioning on behalf of the counsel for the petitioner, Your Lordship, here. It may kindly be listed after 2 weeks.
Miss
Vite.
Learned counsel appearing on behalf of Mr. Santianger, learned counsel for the revision petitioner. Prays for listing this matter after
3 weeks.
3 weeks. They are not objected. List this matter after 3 weeks. Okay. Yes.
My lord, if item 25, it can kindly be listed next Thursday.
It's in the order.
Yes, it's in the order. Yes, 25 and 26.
Is prayed for by both the learned counsel for the
Otherwise, we can wait, my lord, to see the service of, if we can wait for the item to be called so that we can check.
Yes, let us see. Okay.
Yes, my lord. Much obliged.
Let it be good.
For motion, item numbers 1 and 2.
Yes, Your Lordship.
Yes.
Lordship, this IA is filed seeking for impleadment of the new incumbent officer, the Secretary Mort, Lordship. While this matter was pending, Lordship, the all contender, the officer has been transferred. So if this Honorable Court may kindly implead the new incumbent, Lordship.
Ms. Mikael, learned counsel for the applicant. This is an application seeking leave of this court for impleadment of Sri V. Umasankar from Secretary, Ministry of Road Transport and Highway, within bracket, North, bracket close, Government of India, as respondent number 8 in civil original contempt, civil contempt number 13, 2024. So, it is submitted that during the pendency of the contempt petition, the respondent number 2, Sri Anurag Zain, the then Secretary, Ministry of Road Transport and Highway, Government of India, has been transferred, and in his place, new incumbent, Sri V. Umasankar, has been posted. Hence, pray for impleading the newly posted incumbent as respondent number 8. The prayer is allowed. Let Sri B. Umasankar from Secretary, Ministry of Road, Transport and Highway, Government of India, be impleaded as respondent number 8 in contempt petition number 13, 2024. With the above, this IA is allowed and disposed of. Okay. And in in view of the order passed in IA C 201 2024 today, and his name, Sri so V. Umasankar, is impleaded as respondent number 8. The petitioner shall file amended cause title by inserting the name of the newly impleaded respondent number 8. The registry shall do the needful stuff. Anyone earlier appeared on behalf of respondent number 8?
There is lordship.
There is.
Yes, there is.
So you have to take steps, or they
Yes,
have already appeared?
the union lordship.
You are appearing otherwise.
But that one is a transparent prosecution. So now you the paying scheme.
Okay, you take a step then.
Lordship.
Okay. The petitioner shall take steps upon the newly impleaded respondent number 8 by a registered post with AD within a week from today.
Within 2 days, lordship.
Within 2 days, okay. List is matter after.
Lordship,
4
in fact, the COP is fixed on the 9th of December, but possible, I think. So if after vacation, lordship.
After vacation, okay. List is matter after 4 weeks. Okay.
For withdrawal from the supplementary cost list, item number 50.
May I please, your lordship?
Yes.
Lordship, here I'm informed that the parties have settled the matter. So if this matter can be, we can be allowed to withdraw this petition. lordship.
Ms. Nikai, Learned Counsel for the petitioner submits that the matter has been settled. Okay. Amongst the parties, and he has and in view of that, she has an instruction to withdraw this writ petition. Okay, the prayer is not. State is also appearing. Okay, okay. Mr. Angami appearing on behalf of the state respondent has no objection. Accordingly, this writ petition is disposed of on being withdrawn withdrawn. Oh, okay.
Much obliged, lordship.
For admission, item number 8.
Yes.
May I please, Lordship?
Yeah.
I'm mentioning on behalf of Visa Mobile, my lord. Later matter will come up after vacation, my lord.
Okay. You are Miss.
Lordship, I'm appearing on behalf of GDK, Bertatep.
Okay. Miss Bhattacharya appear on behalf of Mr. G. Dekalana, counsel for the petitioner staff. Mr. Tibabam appearing on behalf of Mr. V. G. Momi, Lana, counsel for the respondent number 1. Praise for listing this matter after
Vacation, my lord.
the vacation. They are not objected. Okay. List this matter after vacation. Okay.
Much obliged.
Lordship, my apologies, in item number 23.
Yes.
Lordship, we kindly direct the registry to reflect my senior's name, Hisin Lohim,
Item 33.
representing counsel for
senior's name?
respondent Hisin Lohim,
Item
appearing
33,
for
huh?
respondent number 5.
23. Okay. The name of Mr.
Hisin Lohim,
Ising
Hisin Lohim,
Law him and
counsel for respondent number 5.
be reflected as Lana counsel for the for respondent number
5.
5 in the course title. Okay. Okay. No, course list, huh? No, course list. Yes.
For admission, item number 9.
Lordship, this is the same item which was listed on Monday, Lordship. 2 questions were raised on that day, Lordship. Whether I have to approach this honorable court under the CRBC or the new PNSS, Lordship, by the Learned
Okay,
Counsel from
okay.
the respondents, Lordship.
Hmm.
Secondly, whether a direction can be given, Lordship, for discharge before the magistrate's court, Lordship, in view of the fact that,
To allow you to file discharge.
yes, yes, in view of the fact that CC is yet to be taken, Lordship. Lordship, in order to satisfy this honorable court that CC is yet to be taken, Lordship, the last order which was passed on Monday on 25th, that is the same day the matter was taken up before this honorable court. Charges are yet to be considered, Lordship, by the magistrate. The last 3rd paragraph, Lordship. In respect of the remaining accused, it is submitted that the CC to be kept in abeyance, Lordship.
Which one now?
The
Order dated?
Last, yes, order dated 25/11/2024.
Okay.
The last
25.
page, yes,
Which? For CBI.
yes, the last 3rd paragraph, Lordship. In respect of the remaining accused persons.
Submitted that the CC will be kept in abeyance as an application. Of course. Why? Why it was kept in abeyance?
This is
There is no interim.
Yes, yes.
but here.
Nothing preclude the chief judicial magistrate to proceed with the case unless there is stay order, specifically staying the further proceeding of the case.
Your Honor,
What-
if you allow me to submit, my
Yes.
learned friend has been appearing in the trial court below the.
Which is why we have been pressing on the interim, Lordship.
But
He is
what is this order? Why this order has been passed in
The-
that way?
That is why, my lord. Had there been a stay order from this honorable court, yes.
There is no stay order. There is no stay order.
stay
Nothing preclude.
But here, my lord, what I'd like to highlight one simple fact is that if your lordship may kindly peruse,
Anyway, okay, yes.
But that is not the issue, Lordship, today.
yeah, that is not an issue, but my
Yes.
lord, here, if this honorable
Okay,
court.
but then one thing is. to
Let us
make
focus on
clear,
the issue that is.
One thing, unless there is a stay order by
Yes,
this
it
court,
cannot be
it is to
stay
be of course made clear in the order itself.
Hmm.
That nothing preclude the chief judicial magistrate to proceed with the
Lordship,
case
there are,
for
to be
trial.
fair, Lordship, there are 3 orders passed by this honorable court, which says that interim will be considered on the next returnable date. So in view of that, Lordship, adjournments have been sought
But
and
the
Lordship,
interim not
because,
yet,
because yes, of course, it has not been considered. And Lordship, if the CC is taken up, then my prayer, the second prayer in the writ petition, Lordship, for filing a discharge petition before the CJM, Lordship, it will be frustrated, Lordship.
probably your discharge petition has already been dismissed or not entertained.
By
Or
the
it was dismissed by the
Sessions
direct
Court.
Session court.
Yes, Lordship.
Then you see, your discharge petition has been, after consideration only, it was rejected. After considering,
Lordship,
after
yes.
hearing the parties,
Yes, Lordship.
on being found prima facie case established against you.
Yes.
And then it was only with the direction to charge.
That is his
to frame
observation,
charge.
Lordship. The facts were not properly considered, Lordship. And in fact, Lordship,
No, no.
the
So you mean to say that the district judge did not properly consider and the chief judicial magistrate will consider properly?
Lordship, now, Lordship, the case is before the magistrate's court, Lordship. Whether it, the issue is no longer arises whether the Sessions Court will consider it properly or not. That issue is no longer there because the case is out of his hand, Lordship.
We are
Yes,
to
yes.
give a little submission in this.
No, no, no. One by one, one by.
Satisfied with the
Lordship, I,
passed by the Sessions Court,
Hmm.
special court.
Hmm.
If they are not satisfied, why they have not come by way of appeal before the Honorable
Lordship,
Court?
Lordship, Lordship.
One by one.
Yes,
Hmm.
yes, that's what I've been requesting.
Yes.
Since day one, Lordship, the counsel for the CBI has been interrupting my submissions, Lordship.
No, no, you'll get opportunity.
Yes, that's what, Lordship. Now, that is what I have been praying for, Lordship.
Okay.
I have not been heard properly at length, Lordship, on the facts of the case, Lordship.
Hmm.
Because, Lordship,
Now, fact, how do we consider the fact?
the facts, Lordship, we are not disputed facts, Lordship, just by going through the report filed by the CPI as well as the FIR filed by the CPI, Lordship. From there, it can be made out that there is no case against me, Lordship.
Okay, then,
Which is why, Lordship, otherwise, Lordship, otherwise I will not approach this honorable court under 482, Lordship, because I also know the inherent powers, Lordship, and the limitations under which the High Court can exercise such inherent powers, Lordship.
okay.
Otherwise, I have other accused also, Lordship, in this same case,
Hmm.
who have never approached this honorable court, Lordship. For them, trial shall proceed before the trial court, Lordship. But here is a case where
There are,
an innocent.
there are other accused
Yes.
in this case,
Yes, yes, yes.
in this
Yes, not,
charge sheet filed on 7.
yes, yes, Lordship. Because, Lordship, there are 6 different allegations, Lordship.
Yes.
Those 5 other allegations are against different, each allegation is against a particular firm, Lordship. So there are 5 other firms, 5 other contractors, Lordship, against whom allegation exists, Lordship. I'm not bothered with those, Lordship, in this. My allegation is the 6th allegation, Lordship, saying that, Lordship, there is shortage of road, Lordship, in the length of the road, Lordship, that is 347 meters short, Lordship. Now, Lordship, how they have arrived at the finding that I have withdrawn money for the work that I have not executed, Lordship, that is nowhere mentioned in the CPR report, Lordship. Because, Lordship, the 347 meter, Lordship, as I have stated the other day, is to be constructed only after the main High Court building is completed.
300 or 27 or 210?
347.
347 meters.
Yes, 1,773 has been already completed, Lordship, way back in 2010, 11, 12, Lordship. And for that, Lordship, bills have been released. Of course, Lordship, not the entire, even for that executed portion, Lordship, not the entire amount has been released to me, Lordship. In fact, out of the
No,
contract, Lordship,
let us just clarify. 300, 3,000?
2010 meters is the
Yes, yes,
length.
2010, that is what I'm
Yes,
saying.
yes.
Ah.
Out of that, 1,773 has already been constructed, Lordship,
Okay.
way back, Lordship.
Okay.
Now, 347 has not been constructed by me till now, Lordship, because, Lordship, let us imagine that this is the High Court building, Lordship. Now, after the High Court building is constructed, I must make a road encircling the main High Court building because
You mean to say that that round also is
comes
a
under
part of-
my work order.
Okay, we including that, it comes 2010.
Yes, Lordship, Lordship. Now, because of the non-completion,
But the finding is that there is a shortage.
yes, Lordship.
Okay.
Now, there is shortage, I have told them also, the
Then
CPI,
you have to prove before the trial court.
Lordship, which is
And then
why,
it was probably measured at the time of investigation also.
yes, Lordship,
It was measured earlier.
there is no dispute,
And
there
then
is
you
no
have-
dispute that the work order is for 2010 meters, Lordship. There is no dispute that I have constructed 1,773 meters, Lordship. There is no dispute that 347 meters is yet to be executed, Lordship. Because, Lordship, one important thing is that no completion certificate has been issued. If completion certificate has been issued and if the entire work order amount has been withdrawn by me, Lordship, because more than 1 crore 9,000 something is yet to be paid to me, Lordship, for that is including the unexecuted portion and the executed portion, Lordship. So the question of me withdrawing money for work that I have not yet executed does not arise at all, Lordship. And at page 38 of their report, Lordship, they have categorically stated that I have withdrawn this amount by check number so and so on those dates because 3 running account bills has already been issued to me for 4 crore 52 lakh something, Lordship.
Yes.
Now work order amount is 5.81, Lordship, gross. Now then under such circumstances, Lordship, where does the question of me receiving excess amount arises, Lordship? And Lordship, they, in their report, in the entire report, Lordship, they have not mentioned how they have arrived at the conclusion, the calculation that they have made, Lordship, on which basis they are alleging that I have withdrawn excess payment, Lordship. Now, the 347 meter is to be executed by me, Lordship. Otherwise, who will execute it? Now, despite stating all those facts before them, Lordship, they have made a false allegation against me, saying that I have withdrawn excess payment, Lordship. This is not the case. Now, my Lord is very well aware that for preventing the abuse of the process of law and for preventing somebody who is innocent from being wrongly prosecuted, the powers under 482 can be exercised by this honorable court.
So according to you, the finding of the CBI during investigation is
Yes,
not
they
correct.
have. Yes,
Not
they
correct.
they have conducted a casual
So
perfunctory
that is
investigation.
why it is to be it is to be established. Or
Yes.
it is to be find out, or it is to be decided after the trial, after the adducing evidence of the witnesses only,
Lordship,
since the charge sheet already filed.
Lordship, even
Isn't
if charge sheet is
And
filed,
just a minute,
Lordship,
just a minute,
Lordship,
one clarification.
filing of charge sheet
Just a
is
minute,
not a
one
part,
clarification.
Lordship, for exercising powers under 482,
One small, very small clarification from the state.
my lord.
State. So by an order dated 10/9/2024, state was directed to obtain instruction with regards to the relevant record with regards to order passed by the state government, whereby the application for granting prosecution sanction against a state government employee, alleged accused persons, have been denied. So you have any receipt, then thereafter also, by an order dated 4/10/2024,
Lordship,
it was reiterated, just a minute. And then CBI also, of course, directed to obtain necessary instruction, citing reason as to why the CBI has not taken further steps.
They have already filed their affidavit.
Just a minute, against the order passed by the state government denying prosecution. After denial of the prosecution, because
Yes, my lord.
on the direction of the
No, my lord.
honorable division bench in Suomoto, you have registered the case, investigated into, and file charge sheet, and an only found material evidence found against the accused persons, including the officers, engineers. but then your request for the grant of prosecution sanction has been denied twice. Thereafter, have you taken any steps for challenging? Because you have found during investigation, it was found against the officers also. Thereafter, have you found, because this is order and direction by the division bench in the suo motu case. Have you informed? Because this is in the suo motu case. You have found out.
Yes, ma'am.
What step thereafter you have taken?
So far, I have not received instruction to that extent after the denial of 2 times by the state.
Because
Thereafter, I have not received.
material evidence has been as according to the finding established against the officers. But then it was duty on the part of the CBI to report to the court who has passed, who has ordered, because your finding essentially you have investigated into, found out, and then submitted, and only the prosecution sanction has been denied. Why you did not inform? Have you taken steps?
To that extent, I have no knowledge. ma'am.
Because this has to go back to the PIL again. Inform, and this has to be probably on the same day, probably it was disposed of PIL. It has to go back.
Please, Lordship.
Yes,
My lord, here I'm appearing on behalf of Visa Mommy. So.
yes, but then state,
So, my lord, I have no idea whether he has received any instruction or not regarding that instruction. As per the direction given by the court.
because it appears CBI, after conducting thorough investigation, has found material against the officers as well as the contractor. And then even FSL report also received, material found against them, signature, everything done. And it involves with the PC Act and of course the conspiracy. So conspiracy cannot be done only by the contractor. It can be, the conspiracy happens only with the connivance of the officers only. How the case will go only against the contractor unless the person who involved in a conspiracy is also tried. How it will proceed? This case has to go back to the division bench in suo motu. I'm sending it back. Because the CBI has not yet taken any step thereafter.
May I please, Lordship? My
Yes.
Lordship.
Let the matter be taken up tomorrow, because this case is handling by Visa Mommy. Let him explain the.
Lordship.
Often instruction immediately.
Yes.
Tomorrow we'll pass order then.
Lordship,
Yes.
Lordship.
Hmm.
Since the day this criminal petition has been filed, Lordship,
Hmm.
one thing, this is not PIL, Lordship. I'm sorry to say this, Lordship, and I did not want to bring.
This is criminal
Yes,
petition. This is criminal petition
Yes.
where you pray for setting aside
Yes,
the charge
Lordship.
sheet
Yes,
filed
Lordship.
against you.
Now I'm.
But then it involves, you see, one thing, you should not bother about it if the trial goes also. Because conspiracy, how it happened, as I said, conspiracy can be done in connivance with the officers. Here, officers are not
Yes,
there.
Lordship.
Officers,
That is there, Lordship.
Hmm.
That is the law, Lordship. Conspiracy cannot be done by a
Yes.
single person, Lordship.
but then
Yes.
here you see, 120 is also there.
Yes, Lordship.
120, it won't make out against you, it appears.
Yes. Now,
then-
Lordship.
For
Whether-
420, just a minute. And one more section is 420, isn't it?
Yes, Lordship.
And 420, will it make out if the officer says that, no, there is no cheating? The same officers says that there is no cheating.
Lordship.
Here is a case where the state has exonerated.
Why am I not being heard on the facts properly, my lord?
Okay, what
Kindly-
other
kindly-
facts are there
Lordship,
apart from that?
Let's start from the beginning then,
Hmm.
Lordship. Now, Lordship, before I proceed with the facts, Lordship, I want to state this categorically, Lordship. I did not want to bring out this subject, Lordship, but Lordship, since the day this writ petition has been filed, criminal petition has been filed, and Lordship, since day one, this court has not been, I may be saying, Lordship,
What more?
that,
Submit.
Lordship, judicial discipline, Lordship.
Yes.
Because, Lordship, this court, Lordship, cannot travel beyond my petition, cannot travel beyond the pleadings that I have made,
This is,
Lordship.
this is under,
482, Lordship.
okay, 482.
Yes, I have some
Probably we
specific
know,
prayers.
probably we know.
Yes, Lordship.
Yes.
Now, Lordship, directions have been issued, which is beyond the prayers made by the petitioners in this petition,
That is
Lordship.
why I'm saying, that is why I'm trying to tell you that 120B, I've seen the section.
Yes, Lordship.
And, sorry, 120B and 420.
Yes.
How can it be proved unless the person who is involved in a conspiracy is also been tried?
Yes, Lordship.
So there is a difficulty. That is why I'm saying.
That is why, Lordship, yes, Lordship has a point there, Lordship, a point of view there, Lordship. Now, so far as I am concerned, Lordship, my case before this honorable court is that I am innocent, Lordship. I am not, Lordship,
And just one
Lordship,
minute, one
Lordship,
minute.
whether there is complicity or not, whether there is connivance or not, whether there is a meeting of minds, a concert of minds, Lordship, of criminal minds, Lordship, that is a different subject matter, Lordship. Now, even if assuming, Lordship, that prosecution sanction was given, Lordship, let us say that the state government officials are, even then, Lordship, I am saying that me as a contractor, me as an independent contractor, Lordship, I am innocent, Lordship. And that, Lordship, the process of law is being abused, Lordship, and that an innocent is being, Lordship, falsely prosecuted. Now, my Lord is very well aware that unmerited criminal prosecution is an infringement on Article 21 of the Constitution of India, Lordship. I have categorically raised that issue in my petition also, Lordship. I have also quoted a couple of Supreme Court judgments on that issue, Lordship. Because, Lordship, this court has to, I request my Lord to see beyond the contractors, Lordship, because the livelihood of so many families are attached to this particular firm, Lordship. Because, Lordship, there are laborers, there are drivers, Lordship, there are some engineers, Lordship, some accountants. All those, the livelihood of those families are also being affected, Lordship. When Lordship, I have a criminal prosecution against me, Lordship, the government is also reluctant to issue fresh work orders to me, Lordship. I am facing that difficulty on a day-to-day basis, Lordship, which is why we don't know when the trial will conclude, which is why we have been praying before this honorable court, Lordship, that here I am a person who is innocent. I am a person against whom, Lordship, a casual investigation has been conducted and without any basis, Lordship, work order has been issued for 5.81 crores, Lordship. I have withdrawn money. Actually received amount is 4.52, Lordship, including the forest royalty and the withheld tax. It comes to 4.81 crores, Lordship. Now, 1 crore 9,000 something is yet to be paid to me, Lordship. That is for the work that is executed and also for the work that is yet to be executed, Lordship. Now, then where is the issue of excess payment being received by me, Lordship? That is the simple.
Your contention is that
and how they have arrived at the conclusion, at the finding that I have received excess payment, Lordship. That is nowhere there, Lordship. Now, which is why I'm saying the allegations are baseless, Lordship. And Lordship, if at all there was any document, any evidence to show that saying that the work has been completed, Lordship. There is nothing, Lordship. I am saying that I have executed only 107.
If the work is not completed, you complete the work.
Yes, I'll complete it, Lordship. In fact, Lordship, Lordship, preparations are being made on my instruction, Lordship.
Also remember, this is not a case where the location, the place is somewhere in the far away,
Yes, I know. Yes, Lordship.
Rajasthan.
Yes, Lordship. Yes.
And then that court sitting, you and me are going before the court here.
Yes.
Without seeing the location or the place.
Yes, Lordship.
Whether it is complete or not, everybody knows, including you.
Lordship,
So the photographs will not help. Everybody knows.
Lordship, even in the CPR report, Lordship, they have stated that I have completed my work, the portion that I have executed several years ago. That is the word that they have used, several years ago, Lordship.
Now we do not know. Is it the same road? Is it the same road?
Yes, Lordship, it was executed. Now,
where
Lordship.
we have visited?
Yes, Lordship.
It's the same road.
Yes, Lordship. Now, it was constructed in
Is it-
2000,
is it
work
com-
order is
is it
2008.
complete? Is it complete according to you?
1,773 is
Just,
complete.
Just honestly, is it complete?
304, I am telling you, Lordship, 347 is yet to be
Tell me
completed.
something, the practically.
1,773 has been completed, Lordship. That is more than a decade ago, Lordship. How long will a bituminous road last, Lordship? In a rainy place like Kohima, Lordship. There is natural wear and tear, Lordship. Traffic is there almost every day on that road, Lordship. So obviously, in more than a decade, Lordship, the road will wither away, Lordship. Now, if it is constructed, work order was issued in 2008, then, Lordship, it is more than 15 years now, Lordship.
As you say that it is not complete, you complete, and in the meantime, and then probably this case, I have found some difficulties in the sense, because the officers, the state government,
Yes.
although the charge sheet, although there is a material found against the engineers, the officers,
Yes,
including of course the contractor, but the state government, it appears that I have seen somewhere that saying that this can be taken up by instituting a departmental inquiry. I don't know why. And then the state government probably has decided to compound a non-compoundable criminal case, which is under PC Act also. I don't know whether this is possible, but then because of that complications, we may have to send it back. So if you want some time, the state, that
Lordship,
the
Lordship,
submission of the state is also to be recorded.
Lordship,
So
my criminal petition is different, the sum mutu BIL is different, Lordship. So
yes,
the issues, the two issues
so
may not
this
be
will-
clubbed
this will remain
together.
here, this will remain here,
Yes.
but then the Suomuru case is to be revived.
No, that, on
Yes,
that, Lordship,
that is to be revived.
on
And
that
then
I have no
here,
issues,
here in
Lordship.
this case, we have to make it clear that since there is no stay order, there is we do not know why the CGM is not proceeding with the case. Chief Justice
No, Lordship,
Magistrate,
then,
unless-
Lordship, I may be,
Part of the petitioner's counsel.
So
Lordship,
in the-
I may be hurt on the interim, Lordship, today.
They are seeking interim from this honorable court.
Yes, because,
And
because
court
there are
has
three orders passed by this,
on
already
three
three orders
occasions,
passed by this
trial
court, Lordship,
he
saying
insists
that
that
interim will be
the
considered on the next day.
charge should be free.
Yes, sir.
Now, Lordship,
Hmm.
they are trying, Lordship, that means my lord is, that would amount to dismissing my petition, Lordship. It would,
Maybe,
yes, Lordship.
maybe.
Then, my lordship,
But then this-
Lordship, no, this is not fair, Lordship. This is not fair, Lordship.
He cannot leave this.
I have not yet passed any order.
System.
I have not yet passed any order.
Yes.
There are three orders, Lordship, passed by this honorable court on 4/10,
Yes. But then there, in the
18/11,
same order, this court has also directed the state.
10/9, Lordship.
In the same order, this court has also directed the state to obtain instruction, necessary instruction. The state has not yet furnished. And then the CBI also, CBI has of course filed a status report, and from that we could come to know.
Now, Lordship,
that
may
these
kindly
things
see
are
the
happening.
order passed on 11th of November,
Yes,
Lordship,
yes.
saying that, Lordship, the interim shall be taken up for consideration on the failure of any of the respondents
Yes.
filing the affidavit, Lordship.
Yes.
That event has already arisen, Lordship. And then, Lordship, it was listed before my lord on 18th, Lordship. My lord was reluctant on that day also, Lordship.
Yes.
Then two issues were raised. Now, Lordship, by the CBI Council. One is that I cannot approach under the CRPC. Second is that, Lordship, whether a direction can be issued, Lordship, for filing a discharge petition before the magistrate's court, Lordship. This is not the second discharge petition, Lordship, because it's a separate court, Lordship. Earlier that,
No, can you just read the last, the operative portion of the district judge or the special judge, PC Act,
Speech 314.
314.
Last paragraph.
thus from the aforesaid discussion along the prayer for discharge of the accused persons cannot be entertained at this stage.
See?
Yes, Lordship. And the other contentions addressed by the defense are not gone into. Even otherwise, with regard to the other contentions addressed by the defense, I am of the considered opinion that the prosecution should be given an opportunity to explain by leading evidence to the IO of the case. Moreover, the court is not required to enter into meticulous consideration of the evidence and materials at this stage. Accordingly, in view of the aforesaid, the prayer for discharge of the accused so and so fails, and they are to face trial for the offences under sections 120P and 14D IPC.
See?
Now, my lord,
So the trial, it's order for trial.
Yes, Lordship.
Trial of
Now-
offense. Now at the trial stage, how do we again entertain, how do we again allow, how the
Yes.
court allow you to file another application?
That has been done, Lordship,
Which-
in
which
other
one?
cases also, Lordship.
Hmm?
That has been done in other cases also. The Supreme Court has allowed, the High Courts have
The
allowed,
duty,
Lordship.
duty now remains on the part of the Chief Judicial Magistrate is to frame charge. Otherwise, you say, in the case, in such case, the special judge should have been
Lordship-
framed charge
Lordship-
against the accused and then send it to the
Why,
CJM for trial. If it
I'm
think-
surprised, my lord.
Hmm.
Why is this court as well as the CPI so hell-bent, Lordship, for criminally
Because there is a
prosecuting?
clear finding against you.
So,
There is a clear finding against you. There is just prima facie material against
No,
you. And the
Lordship,
court has also observed.
no,
Then where you see, how do we reappreciate and say that you are
Then-
innocent?
Lordship,
You expect that.
the Lordship, I am not saying that a witness box may be opened here, Lordship, and the evidence may be considered, Lordship. I'm only saying that, Lordship, the CPR report, Lordship, is baseless, Lordship. There is nothing against me.
That is his contingent. Our
Because
contingent-
Lordship, for alleging a crime under 120B of the IPC, Lordship, and 420 of the Indian Penal Code, Lordship, there are certain ingredients. Those ingredients must be present, Lordship. Prima facie, Lordship. Now there is nothing.
And then just a minute. Huh? The
Now let
object-
us forget about 120p for once. But Lordship, 420 IPC has to be established first, Lordship, in order for 120p to be attracted, Lordship. Now, the essential requirements for cheating and dishonesty, Lordship. There are legal ingredients, Lordship, legal requirements to be fulfilled. Now that is not present. And Lordship, I have been made to run from pillar to post, Lordship. And when I have been, despite me being innocent, Lordship, I have fully cooperated with the CPI, Lordship, in their investigation. And in their investigation also, Lordship, the statements that I have given, Lordship, those were not fairly recorded. But despite that, Lordship, the fact of the matter remains, Lordship, that due to the non-completion of the High Court building, the 347-meter, Lordship, isn't that a reasonable submission, Lordship? I am not concocting facts here, Lordship. I am the contractor who is going to be constructing those 347
What is
incomplete
the
portion,
record?
Lordship.
Record. Oh, it's there.
Lordship, it may be listed on Monday then, Lordship. Two questions were asked on Monday, Lordship, which is why I came prepared on those two questions, Lordship. And today, this court is going in a different direction, Lordship. It appears there's
So that is
a predetermination, Lordship.
that question, that two question which we raised,
Yes.
probably it can be entertained under CRPC.
Yes, my lord.
Okay. And then another question is, what was the another?
To allow to file discharge petition.
Okay,
Yes,
so that I have just shown you
Yes.
that cannot be, because once your petition was, petition failed after hearing, detailed hearing of the parties, you failed, then how do we again give you an opportunity, another
And by
opportunity?
exercising powers under 482, Lordship, because that has been done in other cases also, Lordship. In other cases also, Lordship.
That you know.
Because I have citations, Lordship, on that, Lordship.
Quite sparingly in very rare.
Yes, Lordship.
Rare after rare.
Yes.
case.
Now,
This is
then,
one of the
Lordship,
rare after rare
Lordship,
case.
then my first prayer, Lordship.
Just a minute, huh? I just wanted to say why.
I may be
why-
allowed to
why-
press on
why-
the first
why
prayer,
this
Lordship.
court is insisting. The finding is that investigation has established that the accused engineers of the NPWD, engineer so-and-so, Vikosworo, EE engineer N. Kiketo Sumi, engineer Kelechuto, engineer Masivili Savino, and J entered into criminal conspiracy with each other and also with the accused contractor. That is a A14, Pepesuto Rio, and his partner, Maileli Rio, Bibialito Kates, and by abuse of their official powers, position fraudulently and dishonestly had made excess payment to the tune of rupees 29 lakhs 68,000 to the accused contractor, as mentioned above, knowing fully well the shortage in length of road and shortage in length of footpath with checkered tiles, and thereby cause huge wrongful loss to the government exchequer and corresponding wrongful gain to themselves to that extent. And on a charge, you see, against them under section 120B, 420 IPC, and 13.2 read with 13.1D of PC Act against them. And then what the state has observed after that, on being sought for the grant of prosecution sanction,
yes.
the government says,
Yes, that is
whereas,
regarding
just
the
a
state
minute,
officials.
just a minute, whereas the officer against whom prosecution sanction is sought appeared to have been negligent and committed mistakes, not completed procedural formalities and necessary checks before making payment, and also measurement books and other documents were maintained carelessly, which resulted in excess payment.
No,
Accepted. This is government. This is letter, the government letter resulted into excess payment. Accepted. This is admitted position. And whereas the officer concerned has
Then-
given undertaking, just a minute, whereas the officer concerned has given undertaking to recover the excess amount paid and make good the shortfall in works. You have not yet done. And that is why
Because there
the
is no
state
excess payment,
that
Lordship.
is why the state was asked to obtain instruction in this case, whether they have compensated, they have made the road good thereafter, because they said that they will compensate and recover, whether recovery made or not, we do not know. That is why I'm saying, why I'm insisting that.
That is regarding the state officials.
And then thereafter, what the state says, and whereas keeping the above in mind, the fact of that the report does not provide any detail on whether the excess payment pointed out by the investigation have led to any personal gains to the officials proposed to be prosecuted, it would be appropriate that instead of criminal prosecution, departmental action is taken. Whether departmental action is taken or not, that report still this court is waiting. So that is why that is necessary. And then thereafter you say by filing for review, requesting for review of this order, the CBI has again made clarify that it is submitted that the act committed by the accused engineer of NPWD will not fall under the category of mere mistake and negligent. Rather, there are sufficient evidence to show the capability of the accused engineers, and moreover, undertaking to recover the excess amount paid will not resolve the accused engineers, not absolve the accused engineer from the offense committed by them. Moreover, commission of offense punishable under section 13.2 read with 13.1D of PC Act is fulfilled if the act of the accused public servant had caused any pecuniary gain to any other person and not necessarily personal gain to himself. So despite of this also, the state has again says that no new evidence has been given. That is why denied. This the court is surprised to see, and then that is why the court insists the state to obtain instruction in this regard. And then after that, because of this observation, the case might go not in this case, not this case.
Yes,
This case
Lordship.
will be, of course, decided by this court only.
Yes.
But then the PIL has to be restored. We
Yes.
have to report it. And then but before that, we need the instruction from the state government.
Yes, my lord.
Mm.
Your lordship may grant some time to obtain instruction.
And then in the status report, the CBI has clearly, of course, mentioned that it's only because non-granting of the prosecution sanction, the matter could not be proceeded. And then in the case, this case, if the court finds that there is a material against the accused to proceed with the under 120B and 420 also, they can proceed with. We have not yet stayed. Because of this reason, the
Which
stay
is why,
is not
lordship,
possible.
I am
Because of
stating that,
that-
lordship, I may be heard on my interim, lordship, today.
I have I have given a detail, and because of that reason, interim is not possible now. Because of this reason only, interim is not possible now. But then it can be, of course, disposed of at
Lordship,
one
Lordship.
go after hearing both the parties. But then in the meantime, we need to restore. We need to get the PIL restored, and then let the Chief Justice decide what to do with that.
Yes, my lord.
Lordship,
Yes.
I may be allowed to place, lordship. This is an order passed by the division bench of this honorable court, lordship, in the PIL, lordship. Here, lordship, excess, not only excess amount, lordship, without executing anything, completion certificate was issued, lordship. For works amounting to 50-60 crores, lordship. Now, lordship, a PIL was filed before this honorable court, praying for investigation by an independent agency, lordship. It was denied, lordship. And lordship, this year, lordship, work order was issued in 2011, 2014, lordship, different work orders, lordship. Lordship, and then this year, lordship, the state government, they modified the work items, lordship. And lordship, no, lordship, I may be allowed to narrate this, lordship.
Yes.
Because I'm concerned, lordship. Now, this honorable court, the division bench, allowed it because, lordship, if suppose if retaining wall is an item, if culverts are an item, those were removed, lordship. If earth cutting is an item, and that because completion certificate was issued in 2014, work order was, it is all narrated here, lordship. Work order was issued in 2011, lordship, and modification of the working estimate and the project, lordship, it was allowed this year by this honorable court, lordship, in a PIL, lordship. Now, lordship, this concerns with the livelihood of so many people, lordship. Now, in that petition, lordship, this honorable court failed to direct an investigation by an independent agency. Now, when it is us, lordship, it is the High Court, lordship, it seems we are very determined, lordship, to prosecute people who are innocent. I have been saying, lordship, that there is the CBI in their own report, lordship. I have taken my lord the other day also at page 38, lordship. Page 142 of my criminal petition. I understand, lordship. As a counsel and my clients also, they understand that this is an important work for the people of Nagaland, lordship.
Yes.
We have demanded for a separate high court, lordship, for a long time, lordship. And construction of the main high court building, construction of the surrounding infrastructure, lordship, the premises, lordship, it is an important step in that direction, lordship. We understand that, lordship, which is why, lordship, we have diligently executed the work, lordship, and for the work that I have executed, I have received payment, lordship. Now, my lord, page 38. These are the check numbers, lordship.
38.
Yes, page 142, that is running page 38 of the CPR report.
Yes.
Para 7.102.
Yes.
This is the first running bill, lordship, that I have received. Para 7.103, this is the second running bill that I have received, lordship.
Yes.
Para 7.104, this is the third running bill that I have received.
Yes.
Now, this accrues to a total of, including forest royalty and withheld tax, 4.81 crores, Lordship. Now this actual amount here that I have received is 4.52. Forest tax is being taken by the forest department, Lordship, and the
in the other.
now,
documents we
Lordship,
have submitted the same.
yes, Lordship. When my work order is for 5.81 crores, Lordship. How can there be excess payment when I have received only?
That is why. So
When I have received
the
only
CBI
now
has
this is
filed.
now yes this is not
You
my
prove-
this is
you-
not
you
my
prove
petition.
you're innocent.
This
You
is not
prove
my
you're
petition,
innocent.
Lordship. This is the CPI's very own report, Lordship.
What it,
Yes, you
he has
prove your
to
innocence.
let him prove. If you say
If-
that
if the-
he's innocent, he can prove it.
Now,
If the
Lordship,
failed
which is
to-
why, Lordship, Lordship, either
The evidence at this stage.
it's not the meticulous, Lordship. Going through the CPR report, Lordship, we are not asking for examination box to be witness
This is
box
the
to be
part of
open
charge sheet.
and
So
examination and
this is the part of charge
cross-examination
sheet.
to be
You prove
conducted
your
before this honorable
innocence.
court.
If they fail to prove against you, then you'll be acquitted only. Why you are worrying about that?
I am worried, my
And,
lord, because time is a factor, Lordship. Now this FIR has
time is
been
a
lodged,
factor. And then
Lordship.
you see, there is a government, as I read out the admission part, and then you have also undertaken to construct the
Yes, Lordship.
thing which has
Yes,
not
Lordship.
been, you do it in the meantime, what we
In the
will do-
meantime, Lordship, then in
the
that case,
meantime,
Lordship.
the state will obtain necessary instruction on that. And then this order,
Now,
about
Lordship,
the swap- about
I have
the
a
swap
request.
order.
Then in that case, Lordship,
Yeah.
I am already making preparations, Lordship.
Hmm.
Equipments are being brought, Lordship, for
Okay, that would
completing
be
the
better. That would be
347
better.
meters, Lordship.
Hmm.
It is already being arranged, Lordship. Now, I
Much-
may be,
much better.
yes, on the next date, Lordship,
Hmm.
if my lord agrees,
Hmm.
I may be allowed to place the completion certificate, Lordship.
Okay.
Lordship. And Lordship, at least till that time, Lordship,
Hmm.
the criminal proceeding before the trial court may be stayed. To be fair, Lordship. I believe that is a very fair submission, Lordship. To be fair on the petitioners, to be fair, Lordship.
I have to seek opinion because I've not been instructed to that extent.
No, Lordship,
Because they have their
yes,
filed
it
their
is,
objection.
it is,
also.
it
They
is,
have filed their objection.
it
also.
is the court's prerogative, Lordship. And that interim prayer, Lordship, exists in my criminal petition also. So what further instruction does he need, Lordship?
So say, for example, for completion of
Yes.
what the government has instructed and what you have undertaken, how long it will take?
I'll complete it by December, Lordship.
December.
Yes, Lordship. 347. In fact, Lordship, I request my Lord to believe me on this, Lordship. Lordship, I want to say something, Lordship.
Hmm.
There is no third of resources, Lordship. I could have completed that 2010 meter long time ago, Lordship. Now, even if I completed, Lordship, this is the problem. Because of use of heavy machinery and the construction materials being dumped at the construction site, Lordship, even if I completed, the road will be damaged and loss will be caused to the state exchequer, Lordship, which is why it was discussed and decided that, Lordship, yes, we'll complete the 347. That is the gospel truth, Lordship.
Yes,
Okay, things which are not in the recorder should not be
Now-
supplemented by verbal, because if that is the case that is done by the petitioner, I should say, the work order is for only 12 months. Why it was not completed within 12 months?
Now, breach of contract,
Wait,
Lordship,
wait,
breach of
wait.
contract
Allow me.
does not attract criminal liability. That law is well
From
settled,
what they have been
Lordship.
told, by which government order
Why is
they
the
have been
CBI
stopped?
raising these kind of issues, Lordship?
They are
Legally
saying that it
untenable
was stopped.
issues.
Because of dumping of heavy materials, the work cannot be executed. It was not
Otherwise,
executed.
delay in contract,
Where
Lordship,
is
it
the
arises
order?
all over the state of
Where
Nagaland.
is the order giving the direction to the contractor to stop the work till the High Court complex is completed? Those all immaterial submission cannot be taken into consideration by this honorable court.
Now, Lordship. Breach of contract, Lordship. It may occur, it may not occur, Lordship. Now that does not attract criminal liability, Lordship. That law is very well settled, Lordship. Put us in. Where's the- 2023 5 SCC 360 Lordship. I have 2023 5 SCC 360, paragraph 13.
So till December, the completion, what about the?
31st
footpath-
December, Lordship.
Sorry,
Yeah, it
31st
will,
December.
Lordship,
What about the
it will
footpath?
be completed along with it because the
Along with all
footpath
those footpath
accompanies the
also?
footpath accompanies the road, Lordship.
Hmm?
Footpath accompanies the road,
Okay,
so it will complete. It will be completed together.
so why you are saying, what is this about?
Lordship, it says that breach of contract. He is saying that Lordship, I am. I did not complete the work within within the. Now, are you saying that Lordship, the 347 meters? Then will the CPI construct the 347 meter?
That will be taken care of by the division bench in the Supreme Court
Yes, yes.
case.
So placing of all the judgment is not relevant. at this
Now,
moment.
perhaps the CPI wants to become contractor. Are they?
No.
Then
What kind of submission is?
What
being
interest the
given? My lord,
CBI has against you?
Lordship-
They have sincerely investigated into, found out.
No,
and
they did not conduct a
submitted.
sincere investigation, my lord. I'm sorry to say this, Lordship, but Lordship, there are a plethora of judgments which says that Lordship, if in 2022 7 SCC 124 also, Lordship, that
What this is about?
that breach of contract, Lordship,
Breach of
it does
contract.
not attract criminal liability.
That will be taken care of by. in
Yes,
the
my lord.
suo motu case.
Yes,
Mm.
my lord. Now, Lordship, no, here also, Lordship, that is an important factor, Lordship, because they are saying that within the time frame I did not complete the work, Lordship. Now, Lordship, because if I complete the work, loss would have been caused to the state exchequer because, Lordship, dumping of the construction materials and the use of heavy building machineries, Lordship, because it's a massive structure. My lord is very well aware, Lordship.
We have no idea about that.
No, Lordship.
Mm.
Lordship.
Because the road
Because, Lordship,
construction- road
these
construction-
days, my lord is aware, Lordship, the huge buildings are being constructed by machines only, Lordship. Human, unlike in olden days, Lordship.
How the road, if the road is constructed properly,
Yes.
how it will disturb, how it will be.
See, my lord. See,
You have to satisfy, you have to show.
Yes.
Submissions
Okay.
made
Lordship.
before the
Anyway,
Supreme Court.
So I have noted your
Why are you
submission that
objecting
it will till
unnecessarily?
December, till
Allow me
December,
to, the
till
court is
December
asking you a
31st.
question. The court is not asking you.
Sure.
No, please.
I may be allowed to make a reply.
No, please,
At
please.
least to the pointed
Please,
question
please.
made to me by the court.
Please, Mr. Santini, you have been given enough time. And then till December, you are saying that till December 31st, it will be completed.
Yes, Lordship.
I have taken note of it.
Yes. Now, my lord, my humble prayer is that, Lordship, at least till the next date, the criminal proceedings before the trial court may be stayed, Lordship. And on the next date, Lordship, I'll place the completion certificate.
Well, after the order which you have shown before this court, that the in respect of the remaining accused, who is this remaining accused?
That is other accused, Lordship, to do with other allegations, Lordship. Not part of, we are not
So
of
they
the
have
same
also
firm.
filed quashing petition before this court.
No, my lord.
No, Lordship. They have not approached this court and then they are to face the criminal trial before the trial court, Lordship.
So
That is to do with other allegations, Lordship. They are not part of this petition, Lordship. There are 6 allegations, Lordship, against 6 different firms. I believe that is to
No,
do with
so
allegation D or
this last second paragraph in respect of the remaining accused, who is this remaining accused?
that is
person?
what, Lordship.
No, not you.
Not us, not us. Not us.
Okay.
Not part of this allegation, Lordship. Another allegation, another firm.
So but that prayer was allowed.
Yes, Lordship. Because, Lordship, on that day, Lordship.
Have they filed the quashing petition?
No.
No.
So this is wrong submission.
That's why, my lord, what I'm trying to highlight to this honorable court is that the petitioner counsel who is representing before this honorable court, he was there present, insisting to the court and not to proceed with the case, saying that there is a case waiting for taking up an interim consideration. On that line, even the magistrate court has went after with the case, which this.
This is before the CJM or magistrate?
Lordship,
CJM.
Magistrate.
Judicial,
Lordship.
judicial magistrate first class,
Yes,
Lordship,
not chief judicial magistrate.
no, chief judicial.
there is no wrong submission here.
Chief judicial, just a minute, chief judicial magistrate or magistrate first class?
Chief judicial.
Chief judicial, okay.
Lordship. Now, I may be allowed, Lordship. Present learned counsel so and so for accused A 12, 14, 15, and 16, Lordship. Now, this A 14, 15, 16 are before this honorable court, Lordship. They are to do with the same allegation, Lordship. They are partners of the same firm, Lordship. This A 12, Lordship, he is to do with another allegation, Lordship, another firm, Lordship. So he is not part of the same case. But
the charge sheet is different, I think.
no, charge sheet is also
Same.
same charge sheet, Lordship.
Charge is same.
Yes.
He is representing that particular case also, even in the trial court.
Yes, Lordship. But he
And
is,
he wants to stay that.
No, whether no separate charge sheet was filed under the allegation under 7,
Yes,
It's a-
there's
it's-
a command charge.
common charge sheet.
Command charge.
Okay,
And the section of law is also command. Section of law is also command. Only that is because of misappropriation or the excess payment or whatever. So A 12 is a different particular person who is concerned with the different country work.
Hmm.
Then the present petitioner before this honorable court, 14, 15, 16, is concerned with the construction of the Topol Line mini highway. Who is before this honorable court, now we are taking this case. Now, do you want to quash the FIR and he says that there should be a stay?
so far
Otherwise-
as we are concerned,
otherwise he
Lordship,
should be allowed to file a discharge petition before the.
A12, Lordship.
one at a time.
A12
It's
can
very
proceed,
difficult.
Lordship.
One at a time, when he submits, no, please.
So. When the matter was fixed for consideration of charges and to proceed ahead with the case, he filed this present petition before the honorable court. And for non hearing of the interim, the matter has been keep on adjourning from time to time on 3-4 occasions. Here the last, that was on 25th, when the matter was taken up by this honorable court to be on that day also. And now the proceeding has been put in appearance by the Chief Judicial Magistrate first class, Chief Judicial Magistrate.
But on 25th, Lordship, to be fair, both the counsel for the CPI as well as for myself, Lordship, yes, we were before this honorable court, Lordship.
But then this was a wrong submission. There is no quashing petition in respect of the other.
Yes.
And then just.
Lordship,
To the
that,
CBI.
Lordship, no, Lordship, this is, see, Lordship, in respect of the remaining accused persons, it is submitted. That means remaining accused is, Lordship, A 14, 15, and 16, who are petitioners here.
Okay,
A 12 is, it against.
okay,
Yes,
this is, okay.
yes, Lordship. So there is
Okay.
no wrong submission, Lordship.
Okay.
So for
So
A
this
12,
is, that is why I was clarifying.
Yes,
from
my
you
lord.
that this is talking about 14, A 14, 15, and 16.
yes, yes, remaining is A 14, 15, and 16, Lordship.
But then your prayer has been allowed.
Yes, Lordship. Because on that day,
Unless we interfere it, it will remain like that only then.
Yes.
no, my
Unless
lord,
we give directions, specific
no,
direction.
my lord, what I'm saying is that, Lordship,
Hmm.
for this, Lordship, it will not remain like that. It will continue, Lordship. Because, Lordship, I don't think A12 will be approaching this honorable court by filing criminal petition under 482, Lordship. Now,
No, you see, it is submitted that the CC be kept in abeyance.
yes, Lordship, for those A 14,
Yes,
15,
kept
and
in
16,
abeyance. Prayer of the council is allowed.
yes,
It's already stayed by the same court. Isn't it? Unless we interfere. Unless we give direction that
against A12, it may continue. So, but
What-
my
what
prayer,
prevent
but,
the CGM
but
to
my prayer
take
is that,
charge?
Lordship,
Hmm.
against A 14, 15, and 16, who are the petitioners in item 9, 10, and 11 before this honorable
So
court today, Lordship.
what we'll do is that this
Yes, at least till the next date,
will
Lordship.
not interfere with this
Yes, my
for the
lord.
time being.
Yes,
Let it be. And then we'll fix next date on after vacation. Date will be fixed. When? Say,
when will the High Court reopen, my lord?
Hmm.
I don't think they have brought out a calendar till now,
No,
Lordship,
there was a
2025.
calendar. Okay, you should have asked one. There is a calendar, proposed calendar. Hmm. Because now we are talking about the January next
Yes,
date.
yes, yes.
So you should have. actually.
Yes, that's true.
Hmm. So this will be fixed
Last week of January.
last week of January,
Yes, ma'am.
okay. Giving one particular date, okay. We will not interfere with this order. And in the meantime, the government will obtain necessary instruction as directed and on 4/10 and then, sorry, 2 dated.
Lordship, until the next date, Lordship.
Hmm?
The criminal proceedings may be stayed, Lordship, so far as the present petitioner is concerned, Lordship. Against the other accused, it can go on, Lordship.
Hmm.
And Lordship,
So 4/10.
14, 15 and
then
16,
just a
Lordship.
minute, huh? 10/9/24 and 4/10/24. Your government will file affidavit form. Okay, in affidavit form. And especially because I have just read out, there is in the status report of the CBI, it is mentioned about, they have annexed the reply of the government and also another letter, reiteration of the denial of the prosecution sanction with regards to that. And then there in the order of the government, in that order, government says that departmental inquiry and then the party has undertaken whether those has been complied or not. Okay. And then this also will be recorded that in the meantime, so the conduct of the petitioner, since you have undertaken as per the order of the government, then you are going to complete. And then by January, we also will receive from the government report, and accordingly the order will be passed.
Yes, my lord. Now, my lord, at least till the next date, Lordship, the criminal proceedings before the trial court may be
We'll say
stayed.
that will not interfere with this order. The order, this is for indefinite period.
No, my lord, my
Till
lord.
the disposal of this
No, Lordship.
criminal petition.
No, 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 no.
No, prayer for the council is prayer of the council is allowed. See, keep in abeyance an application for quashing of. Just a minute, an application for.
No, it is just a submission, Lordship.
It's considered to be.
Considered and allowed only. You pray for keeping the proceeding abeyance, and it was allowed only. Will say that will not interfere for the time being.
My lord, my lord,
Okay,
my lord,
then
my lord.
stand only.
My lord.
Because otherwise, what I was thinking is that in view of the fact and circumstances of the case,
lord.
we cannot stay. I was under that impression, but then since you are already protected by the trial court itself, will not interfere at
My
that
lord, my
moment.
lord, my
Okay,
lord, my
so
lord.
accordingly, I'll pass order.
My lord. Then, my lord, it may kindly be reflected that the order passed on 25/11/2024 will not be interfered by this honorable court.
We'll say.
My lord.
Let us.
That will amount to allowing instrument petition.
No, for the time being.
Also to my lord. It will amount to.
No.
Allowing instrument criminal petition, if that is so. Because he is challenging the FIR, he is challenging for stay, he is praying for filing of discharge.
We have to be fair,
But
Lordship.
of course.
The CBI has been unfair till now, Lordship.
My lord,
In
what
the
is-
investigation as well as before this honorable
Please don't
court.
doubt. Please don't doubt. Okay, so to that effect, the order will be passed.
Just to be fair enough, my lord,
Yes.
if the contractor wishes to continue with the work, there should be a judicial order. Otherwise, I'll be sick, I'll be in a very tight.
That I have
position.
noted, that
Yes.
I have noted that he will be completing,
Yes.
because this is going to be listed in the month, the last part of January. Then the completion, he has undertaken to complete the
By,
work
if,
till.
my lord, then
January
if we
31st.
can be given it till 10th January.
Okay.
2025.
Till 10 January.
Yes, my lord.
So that will be given.
But
No,
I would
my
think-
brother,
wait, file my
will
objection.
complete in December.
You want has to go.
Hmm.
After that.
Let us see what
if
we.
the arrangement has come,
Hmm.
without the judicial order.
The case will remain only, but at the moment, what we need is that he should complete the work.
Yes, yes.
The case will remain, it cannot be changed, the offense has already committed. Hmm. Okay.
No, my lord, my lord,
Counsel for the petition.
I wish, my lord, that for wrongful prosecutions, lordship, there was compensation.
Let us see. Yeah.
And will
Learning
be-
counsel for the
on that extent,
petitioner. Also heard Mr.
My lord, I'm appearing on behalf of Wizumomi.
Okay. So, CBI is respondent number?
One.
Okay, Mr. Bandang Wabang for the respondent number 1 CBI and Mr. Tibapong appearing on behalf of Mr. Vijimomi, learning counsel for the state respondent. Okay, then the rest will do. Okay.
Much
Much
obliged.
obliged.
Okay. 9, 10, 11, yes, it will cover only. Mm. Yes.
For orders, item numbers 25 and 26.
Yes. Paperwork? It's there.
Yes,
Okay, have you received? Okay, then you have received, have you?
Your lordship, kindly give me some time. Leading counsel will be appearing for this matter.
Okay, so paperwork, have you received? Oh, no. He will be appearing today, now?
Yes, yes, yes.
Okay. Okay, Mr. Santing, have you received that paperwork?
Yes, paper book.
Okay, then we can fix it for hearing.
Yes, my lord. My lord and lordship, if an order can be passed, because there is a notification issued by this honorable court saying that lordship modifying the chapter 2 rule 7, I think, page number 17 of that Gauhati High Court rules, by which lordship, the impleadment of complainant, FIR complainant,
Hmm.
it is not mandatory now.
So this is what case? What case is this?
POXO.
POXO then?
Yes.
POXO probably is necessary.
No,
There
my
was
lord.
there was a suo motu PIL
My lord.
by the Chief Justice of the Honorable Guwahati High Court. That,
And
and thereafter some notification also issued.
oh, no, my lord, it's not POXO, my lord. NDPS.
NEPS, then NEPS is not required, not required. So then,
Yes.
okay, heard Mr.
So many cases now, so yes.
I think, learning counsel for the petitioner. Also heard Mr. Angami, learned PP for the state staff. The paperwork prepared has been received, has been received by both the learning counsel for the parties, and the matter is ready for hearing. List this matter. After?
Next week, lordship,
Okay, list this matter next week.
next Thursday,
For-
if my letter
Next
friend
week
agrees,
for hearing. Okay, we'll say next week. Okay.
for hearing, my lord.
Okay.
Much obliged.
For orders, item number 31.
May I please, my lord? On the last occasion,
Yes.
instructions were sought for, lordship.
Just a minute. Huh? Hello. Take this. This is earlier case. Put it within the chamber. Okay. This earlier case. Keep it in the chamber. Need to dictate. Huh? No. Okay. File record received. What is this?
Lordship, on the last question, I've been directed to obtain the remission earned by the convict within the jail term.
Hmm?
The remission earned by the convict
Oh, remission, okay.
Yes, remission, the instructions was with regard to the remission that is
Okay,
available.
the remission,
Yes.
that,
Anyway, the subject matter is not exactly the remission, Lordship.
Yes.
no, no, because the time,
Time
he has
frame,
very
yes.
less time.
Yes.
That is why the remission was necessary
Necessary, yes.
in order to just to
Ascertain when he can
to
be.
ascertain
yeah.
whether,
So
Okay.
he has earned 410 days. And this
410 days.
410 days.
And
Lordship.
probably
Probably
he is entitled.
Yes, and
Now.
now
Not just entitled, but he should have been released
Hmm.
already by now, Lordship. So that will amount to again wrongful incarceration, extended incarceration as well. my
But then
lord.
you have also approached very lately.
Lordship,
That-
yes, I approached
And
the
then-
authorities
And unless,
in 2023 last year, the authorities at least,
Unless-
because on the ground that, my lord, it is my specific submission that it is a settled proposition of law. That's the
that
set
is-
off period under section 428 is a mandatory and statutory provision which has to be applied automatically, Lordship.
yes,
There need not be a direction from the court to,
but then here is the case where
Yes,
the
Lordship.
Land Trial Court has specifically mentioned
yes, my lord.
from today.
From today, that was
That-
the
that-
error.
that was the
Lordship.
difficulty.
Yes, that is the
That
difficulty.
should
Yes,
not have been actually.
admit to that, Lordship.
Hmm.
That was a difficulty, maybe, but the authorities, the
Hmm.
jail authorities should also be vigilant about the law.
No,
as well
after
as-
after this, being aggrieved for, of course, it's been a long time, you should have been approached, or the jail authorities should also
Should have taken some steps towards that, my lord.
If the jail authority think that
Yes.
the accused inside a jail cannot approach or has no capability
Difficulty,
of doing
Lordship.
that,
Yes, he has no access to any
the jail
legal advice,
authorities
Lordship.
also have been asked.
Yes, and
And
this,
confirm from the concerned principal district judge
yes, exactly.
about this.
Exactly.
What does it mean?
Yes.
Otherwise, because they need to calculate.
Lordship,
allow-
and as per the this letter, tentative date of release is expiry of sentences 14/2/26.
Hmm?
14/2/2026.
Okay, so as per calculation, as per the judgment,
Yes, yes.
okay, but then,
So unless that set of period is allowed,
Lordship,
he still has to serve.
Lordship, allow me to make one submission.
hmm,
I just received the instruction now.
Hmm.
If the matter can be taken up at 1, let me make some calculation and then I can assist this court.
No, no,
my lord.
Lordship, the issue here is, I think this is not very relevant. Because if the set
It
of
has to be,
period, the set of period, whether this honorable court will allow the set of period or not.
this is with regards to the calculation
yes,
as per the judgment,
yes, my lord.
that as per the judgment,
Yes.
that it will take effect from today. Today means on that day, the
Yes,
date of the judgment.
yes, my lord.
So, but then your case is different.
Yes, my lord.
Hmm.
Allow me to just satisfy this court, my lord.
Mhm.
Now, the tentative date of release is, according to the instruction, tentative date of release is 14/2/2026. That is without the set off.
Yes.
Now, the set off, since the set off is a mandatory provision, if the set off is granted, my lord,
Hmm.
he is entitled to 777 days of set off, my lord, which he was, which
So
he-
that expired on when, according to your calculation? From the date when he was arrested,
my lord, from the date,
without calculating or deducting the remission.
without deducting the remission, it will be 9/6/2025, my lord.
25,
Yes, my lord.
okay. And with remission, it will be 14, no, not
14.
remission.
Yes.
So,
14 days.
just a minute. So without minus sentence undergone, it will be 14/2/2026.
Yes.
Hmm.
14/2/2026 without the set of money.
Hmm. Actually, it should have been the date 9/6/2025 minus remission.
Yes, my lord.
Hmm,
After
so-
the set of minus,
Okay,
minus the remission, my lord.
okay. Okay, I'll take the fact, okay. Hmm.
May please, my lord, I may be allowed to just to assist this
Okay,
court
yes, yes,
to
please.
just make few submissions regarding the settled legal position of law, my lord,
Yes, yes.
regarding set off, my lord.
Hmm.
So now, my lord, set off, as I've mentioned and even categorically stated in my petition, my lord, the set off period under section 428 and the corresponding section is 468 in the BNSS. It is a statutory mandate which should be granted to every convict
Yes,
or ship.
yes.
So it is a settled legal position. It has to be, and the settled position is that it has to run automatically. It has to be provided automatically with or without it being mentioned in the judgment, my lord. In some judgments, the learned court specifically denies for one reason or the other. That is another subject matter. But in cases where it is not mentioned, my lord, it has to be automatically.
That is the automatically.
Yes,
That is
automatically.
automatic
So
only.
to make my submission, to support my submission, allow me to just make two short citations, my lord.
Okay.
2003, 2 SEC 439. My lord, as per the sections, there are only two requirements. Under section 428, there are only two requirements.
4 SEC,
2003, 2 SEC 430.
SEC.
Yes, 439. Just para 8. I'll just cite para 8.
Okay.
May I read, my lord?
Para
Para 8, my lord.
8. Yes.
The two requisites postulated in section 428 of the code are, number one, during the stage of investigation, inquiry, or trial of a particular case, the prisoner should have been in jail at least for a certain period, which the present petitioner has. Number two, he should have been sentenced to a term of imprisonment in that case. So there are only two requirements. One is he should have been in jail during the period of inquiry, investigation, and trial. And second, the second condition is that he should have been imprisoned for a term term of imprisonment has to be specific. Now, in my case, my lord, a specific term has been given, lordship. So these two requirements have been met, my lord.
Investigation for a particular case. Term of imprisonment in that case. Okay, yes.
And the second, my lord, that 2018 2 SCC 496. Just one paragraph, my lord.
2000?
2018 2 SCC, page
18,
number
2018.
2018
Hmm.
2 SCC 496, my lord. Paragraph number 17, my lord.
Hmm.
Accordingly, we allow me to read, my lord.
Para 17.
17. Just a last sentence, my lord. I want to
Okay.
focus here. I just
Hmm.
want to point out to this court. Needless to mention that the appellant shall be
17.
17, my lord. Should I read the entire paragraph, my lord? 17.
Okay, just you are reading from?
Paragraph number 17.
Yes.
Should I read the entire paragraph, my lord? Accordingly, we
Yes.
partly allow this criminal appeals number such and such, filed by original accused number 1, Atul Thakur. We modify the impugned judgment of the High Court against the appellant in respect of nature of offense and instead restore the order of the trial court in that behalf. The appellant is held guilty of an offense punishable under section 304 part 2 IBC and is sentenced to undergo rigorous imprisonment for a period of 10 years with fine of rupees 10,000 in default to undergo further imprisonment for 1 year. Here, my lord, I want to focus here. Needless to mention that the appellant shall be entitled to set off under section 428 of the Code of Criminal Procedure. So
Yeah,
the
that
word
is-
needless to mention, that means it specifies about the automatic application of
That-
section
that is
428. my
automatic
lord.
only. In all the cases, in all the judgment,
Yes, my lord.
the trial court don't mention this 428 because that is automatic.
Yes, sometimes they
In
mention.
some, in
like-
some cases,
Yes.
they used to mention.
Yes, my
They
lord.
used to mention.
Yes. Since my lord is my lord, on my next, if my lord, my next citation, before that, my lord, before that, I want to make one submission.
Yes.
Now, according to the instructions, according to the remissions, instruction that we have received today, my lord, it appears that he should have been released on April 25, 2024. This year, my lord. Now he has exceeded his
Should have, no?
term of office, my lord,
No, he should
term
have
of
been
incarceration.
No, no, just,
No, after the set off, as well as applying the remission.
so
my lord.
when you said, according to
April 2024, my lord.
April 2024,
April 25th, 2024, my lord.
25. So which set off?
Which set off
Which set off
and
and remission?
my
And
lord.
remission,
Yes,
that's
my
where
lord.
you are entitled to be released on 25/4.
Yes,
So,
2024.
okay.
He should have been already released, my lord.
Hmm.
So on the records, on the face of records, my lord, there has been a miscarriage of justice. That is my submission, my lord. So there, and this, for this act, my lord, there's no fault on the part of the petitioner. And the state, in my humble submission, the state should at least be held liable for this omission, my lord. So since this honorable court has taken notice of this instruction and this position, my lord, there need to be at least a consequential order to the effect that remedy, of course, there is no remedy to wrongful incarceration even for a single day, but at least, my lord, a consequential order to the effect that at least some amount of compensation should be paid by, should be directed to be paid by the
No, if
state,
we
my
have
lord.
to modify,
Yes, my
The
lord.
order, there is of course so many defect here. So if we have to modify the order, there is also no fine even. Five, what is directed to pay sum of rupees 1 lakh as relief. For a relief. What is this? Father is for that. This is victim cover. No fine also. And on failure to deposit fine, then the father, I think,
No, my lord,
some sentence.
my
If
submission
we
is,
have to modify.
yes, my submission is that, my lord.
Yes.
My submission is that
Yes.
since
Mm.
we did not have anticipated, we could not have in fact anticipated this, my lord. We thought that we were liable to be, be released after the set off. But now on the face of record, my lord, it appears that, my lord, he should have been released earlier. So because of that, my lord, I'm making a modified submission that at least a consequential order to that effect should be passed. And at least, my lord, the state should be held vicariously liable for this, my lord. So to support my contention, my lord, my submission, allow me to just cite one citation authority, my lord. That's a short one, my lord. And I'll leave it to you on that aspect, my lord.
Oh.
2000, my lord, allow me to just
No,
press the
because
authority.
the order still exists, huh? One thing.
Which order,
in
my lord?
this, the order, from this day still exists.
Yes, I know. Yes, my lord. That
So
is there, but
so
there is
in
omission.
existence of such order, the state may not be able to, unless it is challenged, unless it is modified.
No,
That is there. Mm.
my lord.
Mm.
Now it is belated, hopelessly barred by any kind of remedy
Mm.
now. And we could not, and the petitioner who is in jail for the last more than 12 years now. Should
No.
have been 10 years, but more than he has been in jail because there was no set off period. So he has not been in access of any legal advice. So there's no fault on him. The
not 12 years,
learned
not
judge
12 years,
below.
Not 12 years, not yet 10 years. Not yet 10 years.
No, my lord, according to if remission has
Supposed
been-
to, supposed to.
yeah.
The order was for 12 years, but
Yes.
then not yet completed 10 years
Yes.
also. Here in this case.
No, the order was 10 years, my lord.
Order is
Yes.
for 10 years,
Yes,
but
ma'am.
then he has not yet completed 10 years. What I am saying is. And then as per the order, it should
Yes.
have been 12 years, but then you have an actual not yet completed 10 years also.
No, my lord, the conviction, the sentence is only 10 years, my lord.
Sentence is only for 10 years.
Yes, my lord.
But he has not yet completed 10 years, what I am saying.
My lord, if according
He was
to
arrested on 2015 only.
Yes.
25 not yet come. So that is why it says that the line PP submits that he should have, will be released on
2024, my lord, not 2025, April 25, 2024. He should have been already released.
no, that is after remission.
After remission, man.
After remission, not yet calculated. We have not yet calculated.
But we have to
Then
take into account the
I'm trying
remission
to
also.
clarify because you says that he has been 12 in.
No, no, no,
12
my lord.
years,
I'm
not
just
12 years.
just an example, my lord. Just, but now after the remission, he should have been released on 2024.
If the remission is granted.
Yes, if the remission.
And then if the order is taken that from the date of his arrest, that has not yet been modified now.
Yes, my lord, but the statutory.
But with the
provision-
passage,
Yes.
with this,
Yes.
this order will, this court will pass an order calculating from the date of arrest.
Arrest. That is.
Yes.
There's no question on that. I'm just modifying my submission.
Yes, yes.
To the effect
Yes, I have
that since he has already been, his incarceration has already been extended, my lord.
Hmm.
A consequential order to that effect to at least pay some compensation
Hmm.
to the convict maybe passed today, my lord. So in support of my submission, my lord,
Hmm.
allow me to just cite one authority, my lord.
Hmm.
2022 2022 SEC online SC 837. Because, my lord, Article 90, if that is the case, if he has been wrong, his incarceration has been extended on the face of record now, and this honorable court has taken notice of that. If that is the case, my lord, if that is the case, Article 19A as well as Article 21 is also infringed, my lord, here. So, my lord, paragraph number 23, just two paragraphs, my lord, paragraph number 23. May I read, my lord?
Yes.
We are not oblivious of the fact that the appellant herein was held guilty in a grave offense. But then, when a competent court upon conviction sentenced and accused and in appeal, the sentence was modified upon confirmation of the conviction, and then the appellate judgment had become final, the conviction can be detained, the convict can be detained only up to the period to which he can be legally detained on the basis of the said appellate judgment. When such a convict is detained beyond the actual release date, it would be imprisonment or detention sans sanction of law, and would thus violate not only Article 19D, but also Article 21 of the Constitution of India. This is what was suffered by the appellant for a very long period. Considering the fact that the appellant is a youth, this long and illegal imprisonment beyond the period of sentence, taking into account the long and illegal deprivation of the rights to move freely and thereby the violation of right under Article 19D of the Constitution of India, the violation of right to life and personal liberty under Article 21 of the Constitution of India, and the mental agony and pain caused due to extra illegal detention, we are of the view that appellant is entitled to be compensated in terms of money. My lord, may just kindly turn to paragraph number 25. On the next page, my lord, if I can just skip the few sentences, my lord.
Okay.
Next page, last page.
Hmm.
Third line.
Hmm.
In this case, we found that the appellant was kept illegally imprisoned far in excess of the legally permissible period of incarceration, despite coming to know about the appellate judgment of the High Court dated such and such. As noted above, he was released only on 16/3/22, which is much beyond the permissible period of sentence in terms of the said judgment dated such and such. In other words, he served out the permissible period of imprisonment on the basis of the judgment dated such and such. The appellant is a youth and he suffered long and illegal deprivation of fundamental rights besides the mental agony and pain on account of such extra illegal detention. It is not a case inviting a is it not a case inviting a consequential or incidental order that may be just or proper? In the decision of Ambika Quarry Works versus State of Gujarat, reported in 1987, 1 SCC 213, this court held that all interpretation must subserve and held implementation of the intention of the act. This position is applicable while interpreting any provision in any statute.
But this is the case where he was released by the court on with a direction, but then it was not released on time.
Yes,
This
yes.
is different.
Facts are slightly different, but my point is on
No,
when
that
he's
is altogether
illegally,
different.
when there is extended incarceration, my lord,
Mhm.
at least to some
But here
extent,
the-
he has
here-
to be.
Here is a case where it has not been calculated, and here is a case where this order has not yet been challenged. It has not yet been modified. Court has not yet ordered. After that.
My lord.
And then if the case, on the contrary, if this court modify
Yes, my
under the case,
Yes,
this
my
is
lord.
POCSO Act.
Yes.
Under the case, if they modify, then the accused may also be fined. And then failure to deposit the fine amount within time, that it will be
That-
for 1 year. It may
Yes.
also extend to 1 year. Then you may have to stay more also.
My lord.
So that
That-
calculation, if we go, keep on going, so that will. go
On
in a
the
different way.
on the remedies available to the
Yes,
petitioner
yes, but
at
the
that point
necessary
of time.
order- Necessary order will be passed here. So what we'll do is, because if calculating from the date of his arrest, and if remission is also minus, then of course it exceeds.
Yes.
But then in the instant case, that we can't do now, because what I'm saying is this order is still existence. This order not yet been quashed, or this order not yet been modified. So this, by this order, by this judgment, it will be modified, and accordingly it will be directed for his release. That's all. We'll do that, pass order.
But my lord, now this
But then
honorable court has taken
compensation will be-
notice of the fact that he should have been released. Then, my lord, he should, a direction maybe issued to release him immediately, my lord.
Yes, that will be,
Yes,
that will
my
be
lord.
done.
That was sufficient.
That will be done. Mr. Tosi Olonkumar, Land Counsel for the petition. I've also had Mr. Angami, Lana PP. So this also, this will be a little longer. So judgment will
we
be
can-
delivered within a week.
Lordship can eh, pass it tomorrow also, if possible.
Let us see if it is complete.
Yes. My lord can pass it in your chamber also.
Hmm.
We're fine, it's fine, Lordship. Well, I'm just concerned because yeah, because my lord, the only apprehension is that he's already exceeding.
We have been pleading for some time.
My lord, I leave it to you,
Okay.
but my lord,
So hearing concluded, judgment reserved. Huh? We have to make some observation here.
calculation also need to be done. Obliged, my lord.
For orders, item number 32.
Yes.
Lordship, the service upon respondent 4 to 35 is still available. Lordship, kindly allow to take substituted notice to publish in the newspaper.
Okay. You are Mr.
Imtijan.
Current counsel for the Mr. Imtijan, current counsel for the petitioner. Start in view of the, this is the basic. Okay. Also hard, Mr. Okay. Gami for the
State respondent
State
1, 2, and 3 months.
respondent 1, 2, 1, 2, and
3 months.
3. Okay. Stop. So, para- in view of the office note dated 25/1/11/2024, the Land Council for the petitioner prays for allowing him to take steps upon the respondent number 5 to 35.
4 to 35. Lordship.
4 to 35 by an alternative mode by of publishing in the newspaper. The prayer is allowed. The petitioner shall take steps upon the respondent number 4 to 5 by publishing the notice in the 2 local newspaper widely circulated in the state. Okay. Within 2 weeks,
1 week, Lordship.
within a week from today by fixing next date for appearance on when? After vacation.
After vacation.
After
yeah.
vacation,
After
Lordship.
vacation, it will need a date. Immediately after vacation, what is the next date? Would be 17. Okay, we'll fix on 17.
Lordship, if it can be in the, somewhere in the last week, the Lordship.
23.
Yes, probably, your Lordship, that
Hmm.
If that was not followed on a holiday. like
No,
23
23.
Thursday.
Hmm.
23 is Thursday.
Yes, I know, because 22 was on Wednesday. Okay. Okay. List is on 23, January. Okay. And then after taking that steps, you file affidavit also. And file affidavit to that effect, after that.
Deeply obliged, my Lord.
For hearing, item number 47.
Yes.
Please, Lordship.
Yes.
Lordship, this This criminal petition is filed praying for quashing and setting aside the FIR dated 16/11/2015, which is registered as GR 328 of 2015, which is pending before the District and Sessions Judge Kohima, Lordship. Lordship, here basing on the compromise that has been made between the parties. Lordship. Lordship, I have next the
Is it
compromise.
joint petition?
No, Lordship.
Not joint
No
petition.
joint, yes, Lordship. We
Whether
had
the- Just a minute. What is the stage of the trial?
Lordship,
Before the trial court?
the CC has been conducted, however.
CC, charge framed?
Yes, Lordship.
Under what offense?
The
For what
offense is 353, 225, 450, and
225 is also there.
Yes, Lordship.
What is the maximum punishment?
Lordship
25?
with the maximum.
Okay, 225.
Yes.
353.
Lordship. 225, 307, 450. and-
307 also.
Yes, Lordship. However, Lordship, there has been, there is no injury as such,
Is there any injury report?
no, Lordship. There is nothing as such, Lordship. And in fact,
No
the,
injury report.
no, Lordship. In
Any
fact,
charges have you?
charge sheet, yes, Lordship. I have
Yeah.
also annexed the charge sheet in my petition also.
Mhm.
However, Lordship, there is no medical document as such, but Lordship, we are here basing on the compromise date that has been made between the victim
No,
and,
because that,
yes,
and the charge frame under which section?
the charges has been framed under section 325, 450, 307 and 34
Charge
IPC.
frame under 307 also.
Lordship,
But you
both there
said that
was
there is no injury report.
Lordship, that is what we prayed
Despite
before
of
the-
not having injury
Lordship,
report, charge
Lordship.
frame under 307 also.
Yes, Lordship. We prayed before the lower court, Lordship. However, on the opinion of the court, that since there was one victim, the alleged victim, Lordship, who was alleged to have bitten by the present petitioner, so the charge was not got, the alteration was not done at the time of CC. So after the consideration of charge sheet, after framing the charges, Lordship, the petitioners approached the complainant as well as the informant as well as the alleged victims, Lordship. And after that only, we have filed this instant petition, Lordship.
No, so. just a minute, huh?
Lordship.
Because unless there is a injury report, a
Lordship.
grievous nature,
Lordship.
307.
Lordship, nothing, yes, Lordship. And in fact, the alleged victim has not even been examined by any of the doctor, Lordship. There is no witness in the list, there is no doctor in the list, witness list also, Lordship. Nothing as such is there, Lordship.
Yes, you're for respondent, private respondent,
Complainant.
informant. Okay, complainant. In the criminal case, the complainant is informant.
Yes, Lordship, informant.
Okay. So complaint case is different. So this is in the criminal case, it is informant. So you have any objection? You have filed any objection? So what you have filed then? Have you filed affidavit any? Supporting the petitioner? You have filed? You have no objection otherwise?
Since the matter has been amicably settled between the victim and the.
Adequately compensated?
Yes.
Lordship, in fact, the victim is also represented. I think he's around somewhere around there.
Victim is also represented?
Yes, Lordship. I have met him as a respondent number 3, Lordship. And he has also filed his affidavit, Lordship, supporting the.
Yes, Ms. Meres, 307 is there.
The section levied against the accused are non-tenable, non-combustible.
Yes.
So your lordship compromise is not tenable, your lordship.
Yes, so 307, have you
Yes.
have you seen the record?
No, since it's a charge sheeted case,
So-
LCR has been.
This is produced by, it's called by this court.
Lordship, the LCR, sir.
This is LCR. I think you need to go through and then submit accordingly.
It's up to your lordship.
Hmm.
Since the report is already here.
In
Because
fact,
you have to
Lordship,
go
I
through.
have, yes, Lordship, but there is, we also applied for the CTC for all the documents when we applied for the documents, Lordship. However, no such documents was furnished to us. We also went through the documents, but nothing is there. And in fact, when it comes to non-compoundable sections, Lordship, I also have a citations where this honorable court as well as the apex court has held that when the parties have compromised amicably, the High Court has the power to quash under 482, Lordship.
That is
So-
there, but then 307 is
Lordship,
something that's so
307,
previous.
I also have that citation
And
also
then,
there.
it's not a case where it's concerned with only the individual, but then it's against the society.
Lordship, that I
There
agree.
has been the small case like the marriage, matrimonial case and a small accident case and other criminal case, small
Lordship,
petty cases of petty offense. But this is 307.
Lordship, to that
We
extent,
have to examine what is the medical examination report, please. What the medical
However,
examination
Lordship,
says and-
the alleged victim who was whom they alleged to have been attempt to murder, Lordship, the victim itself has already stated in the document that nothing as such has been done by the present petitioners, Lordship. They have also given the
I have instructions that
Yeah, for the victim.
yes, he doesn't want to pursue the matter. And
It's not a question he wanted or not.
My
He will be compelled, and if he doesn't appear, non-bailable warrant of arrest will be issued against him.
Your Worship, I have filed my affidavit also in this regard.
Mhm.
In my paragraph 5,
Hmm.
I have clearly stated that there was an incident that happened.
Okay.
And the IO has charged him under these sections, but I'm not pursuing that. So I leave it to the.
It's not only the case where the police has investigated and found prima facie case and filed charge sheet, but then only thereafter also, the court has framed charge against him under 307. That is why the question arises.
I understand, Your Worship. However, Your Worship, whether if I'm not willing to cooperate with the agency, then whether this will.
Lordship, it will turn
whether
into
they-
fidelity, Lordship.
That's like, and I'm specifically stated I'm not interested to pursue. So I
Then
leave
for-
it to Your Lordship. As Your Lordship has said,
Then for
it's a crime
lodging
against-
false complaint. False FIR, you.
The Lordship, the complaint was FIR was lodged by the respondent number 2. That is the then it is Lordship. In fact, if we see if to understand the facts of this case, Lordship, if the Lordship may kindly come to the agreement, Lordship, the compromise
No,
deed.
agreement is fine, but then
There's the
concern with
full of the facts.
the material on record,
Lordship.
what it speaks, what it says. So because it's understood
Lordship.
that since you have come into the compromise, but then whether the state agree with that is now concerned.
Lordship, when the parties have
When the
amicably
charge was
settled, Lordship,
No,
the charge was
no,
when
that in all the case, it's very difficult. In all the cases, it's difficult. The helps will commit all kind of a criminal crime
Lordship.
against a person who doesn't have, and then there will be no case against any of the person who have.
Lordship.
Then in that case, it will be trouble. That is why we need to see.
Lordship, I understand, Lordship, but
the
I
case.
also have side issues where the 307, 305, 4A, and the all
It
are
depends on
quashed,
the,
Lordship.
it depends on the
And
case.
in
That is
my
why
case, Lordship.
I'm interested in the.
Yes,
record.
Lordship, here nothing has been, no such injury has been caused to the victim, Lordship. Nothing on the record shows that there was the supporting, there is no cogent materials.
Miss
was
Mary,
effect, Lordship.
you just see the record.
It may not be material here, the intention, Your Lordship.
Yes, the
Yes,
intention. That is
yes,
why I'm saying
yes,
intention.
Yes,
Intention with injury.
yes.
So that you just find out and then flag it, and we'll list it tomorrow and pass order.
Lordship.
Your Worship, tomorrow, I have some personal difficulties.
You have, of course, submitted your part, and you are not going to cooperate also.
And I have some difficulties tomorrow also. So,
And
on Monday.
Monday. Hmm. Today afternoon, is it possible then at 2?
I'll give you later.
Hmm?
I'll go through the.
Okay,
report once.
so then if you are ready, then inform the court. We'll take up.
Okay.
Take up and just see the records and an intention, you just see if there the intention and the injury report. So that too, we are concerned. Otherwise, the parties have compromised with, out of the court. And then the parties say they have no more grievances against the accused. So, but then that can this court go ahead with that or not? No? So at 2.
Okay.
Okay. Adam, any other matter? No.
One more.
One more. 48 is for hearing. The person ready, the party is ready.
Yes, Madam.
Okay, Act 2. Yes, Ms. Mary?
I've perused the record. However, your lordship, the examination of the victim, that could not be found.
Examination of the victim.
Yes.
So that is
Medical
actually.
examination is
Ah.
not found. But your lordship, it's not a single section. 4 sections are all non-bailable, your lordship.
Okay.
So even if 307 could not be established, your lordship, 450, 325, all these are non-bailable.
415.
Yes, 450 house trespass, 325 voluntarily causing grievous hurt, and then yes, section 34. Probably there is command intention, your lordship. but that could not be ascertained as of now. It may
You're
be
praying on
ascertained.
behalf of how many petitioner?
Three of them, Lordship.
Or three petitioner?
Lordship.
Okay. 34.
Yes, 34.
Okay, can we just see once the FIR, what's the allegation? What is the allegation?
Page 10 of the repetition, Your Lordship, of the criminal petition is the FIR.
Yes. Okay, numbering around 10 to
Yes,
15.
10 to 15. That means there is probability that pre-plan is there, Your Lordship. So this all can be ascertained only at the time of the trial, Your Lordship. Since it has been charge sheeted and charge has been framed, Your Lordship, let them
Get out the
stand
office.
trial.
Get out the office.
Yes, Your Lordship.
What representation brought by? So they wanted to submit representation.
Lordship, Lordship, the present issue erupted with regard to the other issue, Lordship, which is we have categorically stated in the compromise state, Lordship. That is at Annex D, Lordship. The facts of the case are here, Lordship. In fact, the IO has not stated all the facts, how it happened, the situation, the present case, how it arose in all, Lordship.
IO didn't know.
Lordship, he has not stated anything in the charge sheet with regard to the how this present issue arose, Lordship. So we have stated in the compromise state, Lordship.
Okay,
The
where?
compromise. It's page 25, Lordship, Annex D.
Okay.
If I may read, Lordship.
Yes.
The present case erupted due to the chain of incident. One of the accused person, Mr. Yantilo Tep, that is the petitioner number 1, Lordship, had an issue with a garage owner. Some days prior to the present incident, he kept his bike in the garage workshop, but when he went to collect his bike in the evening, the garage was closed and the owner refused to open. Therefore, he broke the garage lock and took his bike. The garage owner complained to the police, which led to the arrest of the so-and-so accused. On being released from the police station after a few days, Mr. Yanchul, along with his friends, went to the office of the ADC Tsimnew on 6/11/2015 and met the AAC to complain against the garage owner, but the situation flared up with some of the debauchees intervened, leading to the heated exchange of words with some debauchees, where some debauchees were said to be mishandled, Lordship. So, following the incident, the then additional ADC Tsimnew lodged a complaint on 6/11/2015 to the police station Tsimnew. It was on the night of the same day that the accused person, Lordship, in fact, they were arrested because of this, Lordship. That day, the accused person went to the house of one Mr. Hitong, that is the respondent number 3, Lordship, at the LDA at the ADC office Tsimnew on the ground that he was recording the incident, Lordship, in his phone. It is alleged that the accused person were assaulted him, Lordship. And thereafter the case was registered. Against this accused person was thereafter only they were arrested, Lordship. However, Lordship, if we see the charge sheet, Lordship, Lordship, there in the charge sheet, the alleged victim, he has clearly stated that he ran away to his father's place just to avoid the fight, Lordship. In the charge sheet, he has mentioned that also, and no harm was caused to him, Lordship. And in fact, initially there were 9 of the accused persons were arrested, Lordship, because when the first issue this on 6/11, Lordship, when the issue rose, there were other youths also they were present there, Lordship. not only the present accused persons, and 9 of them were arrested. The few of them were not charge sheeted, and one of the accused, 4 of them were charge sheeted, Lordship. However, one of the accused, we filed a discharge petition, and again, he was also discharged. There was a bare allegation met in the charge sheet, so we filed
Discharged by?
discharged by the district and session court, Lordship. So he was discharged, that very accused. He was charged sheeted only on under
So at the time of
325.
framing charge.
Yes, Lordship, before the charge was framed, yeah. We filed a discharge petition for that accused person, and then he was
There
discharged.
was nothing against him.
No, Lordship, 325 was the, but even the very alleged, the statement which the very accused alleged to have assaulted, Lordship, the lady, is also the cousin of the very alleged accused person, Lordship. So the discharge was, she gave an undertaking, and she was discharged from the case, Lordship. And he was discharged, Lordship. So after that, the CC was conducted for the only these 3 of these petitioners, Lordship. And
So how many victims are there?
in fact, Lordship, there,
Says that some other the versus members
yes,
were also
the
there.
deposits, Lordship, it was mishandled by the other persons, not the present petitioners, Lordship, in fact, because there was crowd gathered at the ADC office.
Okay, mishandled by
Yes.
the other accused person. Whether
Other persons.
that other person.
Lordship,
also
there is
charged.
nothing as mention of that. These 3 petitioners were arrested because though they were present in the place of the ADC office, Lordship, in the premises of the ADC office, they were not arrested on that place. They were arrested when they went to take the video of that incident, Lordship, from the present respondent number 3, Lordship. That is only when after that only they were arrested, Lordship. So the IO charge sheeted against them under these sections, like alleging that they went to with the
Total, how many victims?
Lordship,
Yeah.
there is one.
Only one.
Lordship, yes.
What about the devices against whom these persons is mishandled? Are they also witness to the case?
No, they are not witnessing the case.
Not
Lordship.
even witness.
No, Lordship. However, they have also signed in the compromise deed. The compromise was made under the aegis of the ADC office, Lordship, some new. Now the DC office, Lordship. The PA to DC has also signed, and even the the representative of the DP, Lordship, one of the DP has signed, and also the present respondent number 3, the alleged victim, Lordship. The compromise that the signature is at page 96, Lordship.
Victim is ADC.
No,
No.
the complainant.
At ADC's office.
It is the
Yes.
LDA. Okay. This is case of which year?
2015, Lordship.
2015.
Lordship. It was charged in 2016, and Lordship, after that, since there were so many accused, someone could not be reached to the accused person, and after the cognizance, Lordship, someone was not reached to the present accused person, and thereafter some though the CC was fixed for some time, but they could not appear on the same day, so the CC could not be conducted. And after that, there was COVID, so no trial was taken place. So only in the year 2023, Lordship, CC was conducted, Lordship.
So only 3 accused.
Lordship.
What about the evidence or the statement, police statement of the other witnesses? Eyewitnesses are also there, since it was the incident occurred in the office. Eyewitness have you gone through? No.
Haven't seen that. Yeah.
No, Lordship. Nothing is such, Lordship. But Lordship, even if the trial is proceeded, Lordship, it will lead to fatality, Lordship. Even the parties have compromised, and there is no other independent witnesses also, Lordship.
The victim is only one victim,
Lordship.
only one.
One, yes, Lordship.
There is no medical document.
That is not the only.
Hmm. So, first thing, so- the witness also out of many people, only 5 witnesses.
Only 5, Lordship.
You have not gone through the statement of the
No.
police statement of the witnesses. Could you find the intention of the accused?
Intention that could not be determined, as of now, cannot be ascertained, but there is probability, Your Lordship.
Lordship,
As per the
probability.
FIR and
Probability does not yet, Lordship.
that will be ascertained only, Your Lordship, by it is the evidence.
There was a requisition for medical examination. So I think, how many accused initially, how many accused persons?
9 of them, Lordship.
9 of them.
Lordship, it's at page
Then it
11.
Appears. This charge was framed on which date?
2006.
23. It says voluntarily cause grievous hurt. The charge also says. And then that is why 326,
325, Lordship.
325. And 307. So what is your submission, Ms. Mary?
So, Your Lordship, my submission is that since section levied against the accused are non-bailable, non-compoundable, the ground of compromise is not tenable.
That is true.
Yes, Your Lordship.
But then she says that there is a citation.
Lordship.
Even in the
Lordship,
non-compoundable case also.
Lordship.
That if Your Lordship pleases.
So that is why I was asking your submission. If the government oppose, it's very difficult. It should be fair.
Yes, Your Lordship.
Hmm.
That's
If there is no case and difficult to establish,
Your Lordship.
fine.
Your Lordship, the sections that it will have the impact on the society, that has to be bear in mind, Your Lordship.
So that is why
Yes, Your Lordship.
if there was intentional harm that caused grievous hurt, and then if the accused person really with the intention to kill commit murder on the victim.
But lordship, if means here is the intention is to be considered lordship. There is nothing on record to show that they had any arms or they were not even armed lordship. So lordship, no, and in fact they just went to extract the copy of the to extract the video lordship. Nothing on record shows that there was intention lordship. Therefore, intention cannot be taken in this one at this stage lordship.
The charge was framed by district judge.
District judge
Yeah?
lordship.
Okay, session judge.
Yes, lordship.
Which court?
Principal District and Session Judge Kohima lordship.
Kohima.
Lordship.
You have annexed the charge sheet or the charge sheet is on record?
Lordship, I have also a next lordship. So and it should be page
on
90.
yes, page 22 of the repetition of the criminal petition.
Okay.
90. Type copy is 22.
In the record
Yes.
also, is it available?
Yes,
It's
lordship,
there,
it's
Lordship.
there.
In the petition, page
Page
Charge sheet.
22, type copy is at page 22.
22.
Yes, Your Lordship.
Okay. Only says that there are medical examinations.
Accused person lordship.
So victim was not taken for medical examination.
No lordship.
It's not mentioned.
No
It's not
lordship.
mentioned.
Then on what basis the grievous injury?
Lordship. In fact, lordship, the IOS stated that it is they have the accused person have admitted to the commission of the offense, lordship, but lordship is well aware 161 cannot be taken even if we go on trial, lordship. So that cannot be, that may also be considered, lordship.
Who is the informant? The lady LDA or the,
The ADC. Of Teminu.
hmm?
The then ADC of Teminu.
Outside his house.
Lordship.
They went to the house of the LDA
Lordship.
victim.
Lordship. Lordship, they are not denying to the fact that they went to the place of the alleged victim, Lordship. However, no such as grievous hurt or the allegation that has been made in the charge sheet was caused to the alleged victim, Lordship.
This was filed on this year only.
Yes, Lordship.
Okay.
Lordship, I may be allowed to place some reliance, Lordship, to support my submission.
Yes.
Lordship.
What is that?
2011-10-705 SCC 11-10. Lordship, 705 bar 13 16 is that. Lordship, this judgment is regarding the section 320 that does not bar 320 would not bar to exercise the power of quashing, Lordship. If I may be allowed to read the relevant.
Yes.
Lordship, it's para 13, page 711.
Para
13-13. May I read, Lordship?
just a minute. Yes.
Para 13. This court observed in so and so para 8. It is thus clear that Mandul Lemay case so and so does not lay down any general proportion limiting power of quashing the criminal proceedings or FIR or complaint as vested in section 482 of the court or extraordinary power under Article 226 of the Constitution of India. We are therefore of the view that if there is a purpose of securing the ends of justice, quashing of every FIR becomes necessary. Section 320 would not be a bar to exercise the power of quashing. It is, however, a defense matter depending on the facts and circumstances of each case, whether to exercise or not such a power, Lordship. And the para 15, Lordship. In view of the above decisions, we hold that the High Court, in exercise of its inherent power, can quash the criminal proceedings or FIR or complaint, and Section 320 of the Code does not limit or affect the power under Section 482 of the Code. Lordship, and again, para 16, Lordship, which is the next paragraph. Para 16, if I may read. We may also at this stage refer to the decision of this court in Manoj Sharma versus State. The court observed that in our view, the High Court refusal to exercise its jurisdiction under Article 226 of the Constitution for quashing the criminal proceedings cannot be supported. The first information report, which had been lodged by the complainant, indicates a dispute between the complainant and the accused, which is not, this part is not related to us, however. It is no doubt true that the first information report was the basis of the investigation by the police authorities, but the dispute between the parties remain one to one of the personnel. Once the complainant decide not to pursue the matter further, the High Court have taken more pragmatic view of the matter. Lordship. As we have indicated herein before, the exercise of power under Section 482 of Article 226 of the Constitution is discretionary to be exercised in the fact of each case. In fact, of the case, we are of the view that continuing with the criminal proceedings would be an exercise in futility, Lordship. And again, 17, Lordship. It is manifest that simply because an offence is not compoundable under Section 320 is by itself no reason for the High Court to refuse to exercise of its power under Section 482 CRPC, Lordship. That power can, in our opinion, be exercised in cases where there is no chance of recording a conviction, Lordship. No chance of recording a conviction against the accused, and the entire exercise of a trial is destined to be an exercise of futility, Lordship. There is a subtle distinction between the compounding of the offences by the parties before the trial court or in an appeal on one hand, and the exercise of power by the High Court to quash the prosecution under 482 on the other. While a court trying an accused or hearing an appeal against the conviction may not be competent to permit the compounding of an offence based on the settlement arrived between the parties in the cases where the offence are not compoundable under Section 320, the High Court may quash the proceeding even in cases where the offence which the accused stand charged are non-compoundable. The inherent power of the High Court under Section 482 are not for the purpose of control by the Section 320, Lordship. So, Lordship, when it comes to compounding of offences, Lordship, in our case, there is no material in record to, even if the trial is conducted, Lordship, even the trial is proceeded, there is no chance of convicting the accused person, Lordship. And Lordship, again, I also have another citation for the non-compounding of offences, Lordship, which is 2014-9 SEC 653, Lordship. Lordship, I'm relying on para 4, 5, and 6. I may be allowed to read para 5, Lordship. Para 4, Lordship. I'll start with para 4. May I read, Lordship?
Para 4.
Lordship.
Okay.
Now the question before this court is whether this court can compound the offences under Section 326 and 307 IPC, which are non-compoundable. Needless to say that offences which are non-compoundable cannot be compounded by the court. Courts draws the power of compounding offences from Section 320 of the Code. The said provision has been strictly followed in Gauhati versus the State of Punjab. However, in a given case, the High Court can quash a criminal proceeding in exercise of its power under Section 482 of the Code, having regarded the fact that the parties have amicably settled their disputes and the victim has no objection, even though the offences are non-compoundable. In which cases the High Court can exercise its discretion to quash the proceedings will depend on the facts and circumstances of each case. Offences which involve moral turpitude, grave offences like rape, murder, etc., cannot be affected by quashing the proceedings because that will have harmful effect on the society. Such offences cannot be said to be restricted that will have harmful effect on the society. Such offences cannot be said to be restricted to two individuals or two groups. If such offences are quashed, it may send a wrong signal to. However, Lordship, this may be noted, Lordship. However, when the High Court is convinced that the offences are interrelated and therefore do not affect the public, personal, or tranquil, when it feels the quashing of such proceedings on account of compromise would about the peace and would secure ends of justice, it should not hesitate to the quashing them. In such cases, the prosecution becomes a lame prosecution. Pursuing such a lame prosecution would be a waste of time and energy. This will also unsettle the compromise and obstruct the restoration of peace, Lordship. And Lordship, the main is para 5, Lordship. In Gauhati, this court has observed that where the High Court quashes the criminal proceedings, having regard to the fact that the dispute between the offender and the victim has been settled, although the offences are not compoundable, it does so as, in its opinion, continuation of the criminal proceedings will be an exercise in futility, and justice in the cases demand that the dispute between the parties is put to an end and peace is restored, securing the ends of justice being the ultimate guiding factor. Needless to say that the above observations are applicable to this court also. Lordship, in this case also, it's the sections are non-valuable in nature, Lordship. And para here also 307 was also attracted, Lordship. In para 6, Lordship, the learned counsel for the parties have requested this court that the impending order to be set aside of so and so has not noticed the correct position of in regard to quashing of the criminal proceedings when there is a compromise. Affidavit has been filed in the court by the complainant Anil so and so, who is a respondent number 2 hearing. In the affidavit there, he has stated that a compromise petition has been filed in the lower court. It further stated that the two sides are living peacefully, Lordship. This may be appreciated, Lordship. It is further stated that he and the appellants are neighbors. They are in a harmonious relationship between those two sides and that they are living peacefully. He has further stated that he does not want to contest the present appeal and he has no grievances against the appellant. The learned counsel for the parties have confirmed that the dispute between the parties are settled. The parties are being abiding by the compromise deed and living peacefully. They have been argued that in the circumstances pending proceedings be quashed. The state of so-and-so has further filed an affidavit opposing the compromise, Lordship. The affidavit does not persuade it as rejected the prayer made by the appellate and the Singapore so-and-so proceedings, Lordship. So, Lordship, even here in this case, Lordship, 307, but the parties has compromised, Lordship. And also, Lordship, 2014-6 SCC 466. Here I'm relying on para 29, 29, merit, Lordship. Lordship, in fact, here the principles has been laid down on how to, with regard to the section 482, Lordship. I may be allowed to read, Lordship. Para 29, the principles has been laid down in this judgment, Lordship. 29, Lordship. Merit, Lordship.
Yes.
29. In view of the aforesaid discussion, we sum up and lay down the following principles by which the High Court would be guided in giving adequate treatment to the settlement between the parties and exercising the power under Section 482 of the Court while accepting the settlement and quashing the proceedings or refusing to accept the settlement with direction to continue with the criminal proceedings. 29.1. Power conferred under Section 482 of the Court is to be distinguished from the power which lies in the Court to compound the offences under Section 320 of the Court. No doubt, under Section 482 and the Court, the High Court has inherent power to quash the criminal proceedings even in those cases which are not compoundable, where the parties have settled the matter between themselves. However, this power is to be exercised sparingly and with caution. 29.2. When the parties have reached the settlement and on the basis petition for quashing the criminal proceeding is filed, the guiding factor of such would be to secure point number Roman 1 is end of justice or to prevent the abuse of process of any court. While exercising the power, the High Court is to form an opinion on either of the aforesaid two objectives. Lordship, I'm relying on 29.5. While exercising its power, the High Court is to examine as to whether the possibility of conviction is remote and bleak, and continuation of criminal cases would put the accused to a great oppression and prejudice and extreme injustice would be caused to him by not quashing the criminal cases. And also para 29.6, Lordship. Offences under Section 307 would fall in a category of a heinous and serious offences and therefore are to be generally treated as crime against the society and not the individual. However, Lordship, the High Court would not rest its decision merely because there is a mention of Section 307 in the FIR or the charge is framed under the provision. It would be open to the High Court to examine as to whether incorporation of Section 307 is there for the sake of it or the prosecution has collected sufficient evidence which, if proved, would lead to proving the charge under Section 307 IPC. For the purpose, it would be open to the High Court to go by the nature of injury sustained, whether such injury is inflicted on the vital or delicate part of the body, nature of weapon used, etc. Medical report in respect of the injury suffered by the victim can generally be guiding factor. On the basis of this prima facie analysis, the High Court can examine as to whether there is a strong possibility of conviction of the chances of the convictions are remote and bleak. In the former case, it can refuse to accept that the settlement and quashing the criminal proceedings, whereas in the latter case, it would be permissible for the High Court to accept the plea compounding the offences based on the complete settlement between the parties. At this stage, the court can also be swayed by the facts that the settlement between the parties is going to result in a harmony between which may improve their future relationship. And again, Lordship, para 30 to 33, Lordship. After having clarified the legal position in the manner aforesaid, we proceed to discuss the case at hand. That this is observation, Lordship. Para 31. In the present case, FIR number so-and-so, that is so-and-so was registered under section 307 to 324, 323, 34 IPC. The investigation was completed, whereafter challenge was presented into court against the petitioner. Hearing charged have also been framed. The case is at the stage of recording of evidence, Lordship. Same with the present case, Lordship. At this juncture, parties enter into a compromise on the basis of which the petitioner under section 482 of the court was filed by the petitioners, namely the accused persons, for quashing the criminal proceedings under the said FIR. As per the copy of the settlement which was annexed along with the petition, the compromise took place between the parties on so-and-so where when respectable members of the Gram Panchayat held a meeting under the chairmanship of Sarpanch. It is stated that on the intervention of the said persons / panchayats, both the parties were agreed for compromise and have also decided to live with peace in future with each other. It was also argued that since the parties have decided to keep harmony between the parties so that in future they are able to live in with peace, love, and they are the residents of the same village, the High Court should have accepted the said compromise and quashed the proceedings. And again, 32, Lordship. We find from the impugned order that the sole reason which weighed the High Court in refusing to accept the settlement between the parties was the nature of injuries. If we go by the factor alone, normally we tend to agree with the High Court approach. However, as pointed out hereinafter, some of the other attendants and inseparable circumstances also needs to be kept in mind, which compel us to take a different view. Again, para 33. We have gone through the FIR as well which was recorded on the basis of statement of the complainant victim. It gives an indication that the complainant was attacked allegedly by the accused person because of some previous dispute between the parties. Though the nature of dispute, etc., is not stated in detail. However, a very pertinent statement appears on record. Respectable persons have been trying for a compromise up till now, which could not be finalized. This becomes an important excerpt. It appears that there have been some disputes which led to the aforesaid purported attack by the accused on the complainant. In the context, when we find that the elders of the village, including the Sarpanch, intervened in the matter, and the parties have not only buried their hatred but have decided to live peacefully in the future, this becomes an important consideration. The evidence is yet to be led into court. It has not even started. In view of the compromise between the parties, there is a minimal chances of the witness coming forward to support the prosecution case, even though the nature of the injuries can still be established by producing the doctors as witness who conducted the medical examination. It may become difficult to prove as to who caused these injuries. The chances of conviction therefore appear to be remote. It would therefore be unnecessary to drag the proceedings. We take all the factors into consideration. Collectively, are of the opinion that the compromise between the parties be accepted and the criminal proceeding arising out of so-and-so be quashed. Accordingly, the order was discharged.
Okay. Anything else? Okay. Where is the victim file any affidavit?
Yes, sir.
Your file.
Yes, sir.
The victim is respondent number 3.
Yes, sir.
Okay, and then you
Respondent number 2.
respondent number 2 also filed.
Yes, sir.
Separately or
Separately.
is there? There is no separate affidavit filed by the respondent number 2. Is it available there? Sir.
Lordship, I filed on 30/04/2024.
30?
04/2024.
me go first, yeah. Yes, this is the 30.
Yes, Lordship.
Okay, pardon, Miss Mikael, non-counsel for the petitioner. I'll take the fact of the case, huh? Rest I will do it. I've also heard Miss Mere, Lana PP for the state of Nagaland. You are for the informant and Miss
Asenla Longkumar.
Asenla Longkumar for the
Respondent.
respondent number, for the informant respondent number 2 and three, Jack for the victim respondent number 3. Stop. Para. This is an application filed under section 482 CRPC for quashing. The proceeding of GR 328 stroke 2015 arising out of the Seminole PS case number 006 stroke 15 under section 353, 325, 450, 307, 34 IPC against accused persons. Against the 3 accused persons. Against the 3 petitioners accused persons, petitioner stroke accused persons pending before the Court of District and Sessions, Court of Sessions Judge Kohima. Para. The brief fact leading to the filing of this petition is that on 16/11/2015,
My Polish Lordship, it's 6th November, Lordship, 6/11. There has been an error. It's 6th. The fire is on, the incident is on 6th, Lordship.
okay. The petition is that the brief fact leading to the filing of this petition is that on 6/11/2015, one Viqueno M. Meratsu laws a written FIR before the officer in charge, Seminole Police Station, alleging inter alia alleging therein that on 6/11/2015. Some youth from semi-new village and town numbering about 10-15, all in inebriated condition, under the banner of semi-new village youth organization, within bracket TVYO bracket close, comma, get out his office. Sorry, get out the office of Additional Deputy Commissioner, Smenio, and physically manhandled some Dabasis on duty within the office premises. Stop. So where is in FIR, there is no allegation that the victim was.
Yes, Lordship. Nothing is on the FIR, Lordship. Just in the charge sheet, Lordship.
And request for taking necessary action. Stop. Basing on the above written FIR, the above PS case number 005. The aforementioned PS case number 005/2015 under section. A case was registered under section. Registered against how many accused persons registered?
Lordship, 4 of them, Lordship.
Huh?
4 of them, Lordship.
Against accused persons under section 353, 325, 450, 307, 34 IPC. And investigated into. Stop. After completion of the investigation on being found sufficient material against, how many accused charges submitted?
Lordship, 3 of them. 1 was discharged, so only the present
Okay.
petitioners, Lordship.
The eye of the case laid charge sheet against the accused petitioners for offense under section. Same section.
Lordship, in fact, Lordship, in the charge sheet, the one who was discharged was separately charge sheeted. And the present 3 of the accused the present petitioners were charged under 325, 450.
Okay, under section
307.
325, 450, 307, 34 IPC. Stop, huh? This was on
Lordship, the charge sheet or the CC. The charge was framed,
on the charge sheet also in the section on 30/11/2016. Stop. Stop. After taking cognizance, come the learned sessions judge Kohima has always stated it was framed charged on 23. Sorry, not 23. One 2023, frame charge against the accused petitioner for to face trial for offense under section 325, 450, 307, 34 IPC. Para. Where is your compromise?
Lordship, it's at annexure D, Lordship, page 25, Lordship.
No, this is type copy.
Page 25 to 5, Lordship.
Oh, this is in the plain paper.
Lordship, in my petition, Lordship, in my petition, it's page 25. The compromise state is on.
In the plain paper.
Lordship, yes, Lordship.
Where is the original?
Lordship, original,
Okay. The learned counsel for the petitioner submits that when this compromise agreement was signed,
Lordship, it was signed on the 29th of January.
where do we find one date?
It is in the third paragraph, Lordship. The parties under careful consideration have met today on the 29th of January 2024.
Okay. I mean that during the pendency of the trial, the petitioners, sorry, the parties have amicably settled the matter and executed a compromise agreement on 29/1/2024. Stop. In the said, in the compromise deed, come the victim stated that victim is a lady,
No, Lordship.
gent,
Yes, Lordship.
stated that
Excuse me.
he is no longer interested to pursue the case. Sorry, he has forgiven the accused persons long back, and therefore he has no longer interested to pursue the case. Against the accused petitioners staff. The victim father stated that the case has been settled in order to maintain cordial relationship between the parties and in the larger interest of the personal relationship of and harmonious in the society stuff, to maintain the harmonious relationship in the society stuff. Whether after this, whether you approach the court?
No, Lordship.
No.
No, Lordship.
And after this agreement, this was in the month of January.
Lordship.
Whether any date falls, and then you appeared before the court.
Yes, Lordship. On
Any witnesses examined?
no, Lordship. Because we filed this application and we were given the stay, Lordship. So the proceeding has been a stay, Lordship.
Okay. Stop. However, since the offense charged against the accused applicants and all the offense are non-compoundable.
Lordship.
Okay. However, since all the offenses charged against the accused petitioners are non-compoundable.
Lordship, my apologies. 325 is compoundable, Lordship.
325.
Lordship, it's compoundable.
However, the offense charged against the accused petitioner under section 450-307 are non-compoundable. And session court doesn't have the power to compound a non-compoundable case. If the petitioner approached this court for with a prayer for setting aside and quashing the GR case number 328/2015 arising out of Semenu PS case number 06/2015 under section 325 450 307 34 IPC. The para The respondent number 2 informant by filing affidavit on 30 April 2024. While referring to the FIR filed by him and subsequent settlement, subsequent settlement of the case amongst the party, stated that he had lodged the above FIR dated 6/11/2015. As on that day, some youth under the banner of Seminyu Village Youth Organization surrounded her office and physically manhandled some Dabasis on duty within the office premises. However, since the party has amicably settled the matter outside the court, he has no objection if the case is compromised. Which would be in the interest of the citizen of Seminyu in general. And the accused and the accused persons and the victim in particular. That the respondent number 3, victim, has also filed an affidavit while supporting the contention made by the accused petitioners, stated that although there has been some altercation between the alleged accused persons / petitioners and between him and the alleged accused person, alleged accused persons. However, since he has already forgiven and the matter has amicably settled between the parties, he has already forgiven the accused petitioners long back, and the matter has amicably been settled by executing executing the compromise deed, he has he has no further grievances against the accused petitioners, and therefore he is not, he expressed that he is not willing to pursue the matter any longer before the court against accused petitioners. Stop. The respondent number 3 also stated that after he has forgiven the accused petitioners, they are maintaining a harmonious relationship amongst the parties. And now they are in good, and now they are maintaining good terms. And this has been done in the larger interest of the personal relationship and the and for the harmonious society. Stop. In view of the above, the learned counsel for the respondent number, learned counsel for the victim respondent number 3 submits that the victim has under the circumstances, the continuation of the case against the accused petitioners would not only cause unnecessary harassment to the accused petitioner, but also to the victim himself, and therefore prays for closing of the matter. Para Miss Mere Lana PP submits that the offenses charged against the accused petitioners. Now, all the offense charged against the accused petitioners are non-compoundable offense except 325 IPC. 325 is compoundable.
Yes, it's compoundable. Yes, Your
Okay. 325 IPC. And therefore, it's not, what is your submission? It's not permissible, not tenable.
Not tenable.
And
on the
therefore,
ground of compromise.
The prayer was, therefore, the same cannot be compromised.
The prayer of the petitioner on the ground of
Okay,
compromise.
the
is
prayer
not-
of the petitioner on the ground of
compromise is not tenable.
compromisation is not tenable. However, she fairly submits that the injury report weapon was also not seized.
Nothing I could find.
Okay.
on the
Fairly
record.
submits that as per the record, no any weapon of offense was seized, nor any injury report of the alleged victim is available. While referring to the case, the trial court record, she also brought to the notice of this court that even the statement, even the police statement of the victim within bracket, respondent number 3 is not available on record. Stop. Under the circumstances, automatically the conviction is remote.
The conclusion, Your Lordship, withdraw. I'll leave it to you, Lordship.
Under the circumstances, she rather fairly submits that. Fairly, under circumstances, she submits that. She leave the decision at the discretion of this court. Okay. Para. Line counsel for the petitioner. Line counsel for the petitioner. Para submits that although the offense charged against the accused persons are non-compoundable, all the offense charged against the accused are non-compoundable except 325 IPC. There is absolutely no material against the accused petitioners for commission of the alleged commission of the charged offenses. So, see, while referring to the record, also submitted that since there is no any specific allegation against the accused persons for commission of the offense punishable under section 307, and then where is the grievous part? What is this? Where is the grievous part for section for the of
325.
325.
Okay. 325 and 307. No any weapon of offense was recovered, nor any injury report of the victim is available on record. Under the circumstances, under the circumstances, there is in circumstances the possibility of accused and the possibility of conviction of the accused persons are remote. Stop. Huh? See, further submits that in the, see for some state, in the, some state, since the cases, for some is that, some state, since the case has amicably been settled between the parties outside the court, and the informant as well as the victim has expressed that they have no further grievances against the accused applicants, and they doesn't want to pursue the matter any longer, comma, the pending, the further proceeding of the case against the accused petitioners would be a futile effort, a futile exercise, futile exercise, stop. And it, futile exercise, and it would be harassment, unnecessary harassment for both the accused petitioners, sorry, for the accused petitioners, the informant, as well as the victim. So therefore, she prays for setting aside and quashing of the above the aforementioned GR number 328/2015 stop. Okay, para. In support of her submission, the learned counsel for the petitioner has taken reliance on the relied upon the decision in PG alias Pappu and others versus Radhika and another, reported in 2011, 10 SEC 705. Whereby the learned, sorry, whereby the Honorable Supreme Court earlier that one relied upon the decision of the Honorable Supreme Court in CG, Supreme Court in CG alias Papua, okay, reported in 2011, 10 CC, whereby the Honorable Supreme Court has observed that Section 320 would not be barred to the exercise of power of quashing and the power and just while holding, and cut that one, while holding that the Section 320 would not be barred to the exercise of power of quashing, has observed that has opined that the power can be exercised in case where there is no chance of recording a conviction against the accused persons, and the entire exercise of a trial is destined to be an exercise in futility. Stop. Para. The learned counsel for the petitioner also relied upon the decision of the Honorable Supreme Court in case Yogendra Yadav and others versus State of Jharkhand and another, reported in 2014, 9 SEC 653, wherein the Honorable Supreme Court has observed And then Supreme Court has held that non-compoundable offense can be quashed or compounded if victim has no objection. The relevant paragraph is reproducing below stuff. You type para 5 and 4 and 5, huh? Okay. Next, the petitioner has also relied upon the decision of the Honorable Supreme Court in Narinder Singh versus State of Punjab. Whereby, State of Punjab reported in 2014 6 SEC 466. Whereby it was observed that the High Court has, whereby the Honorable Supreme Court has held that the High Court has inherent power to quash the criminal proceedings, even in those cases which are not compoundable, where the parties have settled the matter between themselves. Is what I'm saying. Okay, themselves, stop. Huh? The relevant paragraph is reproduced below. What was the paragraph where it says that
29.6 438, Lordship.
.6?
Lordship.
Okay. Relevant 29.6.
0.6. Yes.
Huh? You just type that one. And which one?
And also para 29.2.
Okay, 29.2 and 29.6.
.5 also, Lordship.
Okay. 29.2, 29.5, 29.6. That's enough?
Lordship.
I cannot give you any more.
Lordship.
So the conclusion part of the clearance. Okay.
Lordship. Lordship.
This is this post. Huh?
For hearing, item number 48.
Item. Yes.
May I please, Your Lordship?
Lordship, this is an application filed under Section 482 of the Code of Criminal Procedure for quashing the proceeding against the petitioner in GR case number 583 of 2023, corresponding to suburban PS case number 48 of 2023 under Section 409 and 420 of IPC. Lordship, this matter arose due to the non-payment of sale value of the goods to the tune of 52 lakhs 9,550 by the petitioner to the respondent number 2. Thereafter, the petitioner was arrested.
What is the petition?
But of the main petition, Lordship.
This is miscellaneous application. Where is the criminal? This is miscellaneous application. IA, this is IA.
Yeah, criminal petition 22 of 2024.
Okay. What is this IA for?
That was
Oh,
for
staying of
stay.
operation.
Yes, Lordship.
It was a state,
No, Lordship. It
not a
was-
state.
No, it's taken up altogether at this stage.
Okay.
You continue, Lordship.
Just a minute, huh?
Okay.
Okay, this. The informant is the respondent number 2.
Yes, Lordship.
Okay, just a minute, huh? And then, what is the allegation against you? Where is the FIR?
FIR is at page 15, Lordship.
Page 15.
Yes,
The
Lordship.
content is at page 16.
Yes. 15 and 16. 16, 17.
Okay, let us just see, read the FIR, huh?
Yes, Lordship.
The allegation against you. Just let us read together. So that undated, from that undated, okay? Page 16.
That on dated 1/11/2023, the above named person came to Dimapur along with his family to purchase the agar wood, and the complainant number 1 has arranged the agar wood worth rupees 52 lakhs 9,550, which was calculated and written in the diary by the accused person himself, and took the goods to Hojai with the assurance that he shall pay the cost of the agar wood as soon as possible. When the accused person did not pay any amount till the month of March 2022, we began to contact him on his phone number. He made various excuses, and from the month of October 2022, he started to behave strangely and even made a statement in such a way that he shall not pay any money for the goods he took. He even told us to go to Kuwait to take the goods back from there. That on 29/8/2023, when it came to our knowledge that the above said person came to Hojai, we somehow got in contact with him on WhatsApp call on his phone number, so and so. On receiving the call, he straightly denied to pay a single penny and even threatened us with dire consequences that if we go to his residence to demand money, then we shall not return alive. He works in Kuwait and presently he is in Hojai. That, sir, the above cited person has cheated us and presently giving us warning with our life. We have faced a huge financial loss because of him, and presently if we go to his residence at Hojai, to demand the cost of the goods, then our life will be in danger. Therefore, we kindly request your esteemed office to register the FIR and take the necessary action as per the provision of law.
The case was investigated into.
Yes, Lordship.
Charge is submitted.
Yes, Lordship. The
Okay,
charge
so
sheet.
submitted
Yeah.
under what offense? For offense,
409 and 420.
same.
Yes, Lordship.
So found case against you. The IO has found case against you.
Yes, Lordship.
Okay, then what happened?
Thereafter, after his arrest, the wife.
He was arrested.
He was arrested, yes.
Okay, then what is the status of the case in the trial court?
It's at CC.
She's charged
Yet to
framed,
be conducted. Yet to be conducted.
yet to be framed.
Yes.
Which court?
GMFC Dimapur.
Dimapur. Okay, then when the case was charge sheeted?
It was charge sheeted on 16/9/2023.
23.
Yes, Lordship. It's at page 24 and 25.
Okay. Just a minute. 16/9.
So, sorry, Lordship.
Just a minute. Okay. And this FIR was lodged on?
FIR was lodged on 0509. FIR was lodged on 0509/2023.
0509.
Yes.
And on the charge is submitted on?
16/9.
Okay. It's very quick. Within a week. Very active. Submitted. Then what happened?
Then the petitioner's wife, along with his relatives, came down to Dimapur and entered into an agreement with the respondent number 2.
On the very next day?
Yeah,
On 8?
On 8 September.
8/9.
8/9, yes.
Huh?
And
No,
on
no, no,
that,
this is.
the agreement.
Just a
Agreement
minute.
is at page 18.
The charge sheet was submitted on?
16.
Okay, 16/9.
Yeah.
Before submission of charge sheet?
Yes, before submission of charge sheet, there was an agreement between the petitioner's wife and relatives with the respondent number 2. Now, in that.
Petitioner's wife?
Yeah.
Why not?
because-
Why not petitioner?
Because at that point of time, the petitioner was in the custody.
Still in the jail?
No, he's out now.
Okay, so what is the settlement says? What is it?
In that agreement, they have met an upfront amount of 15 lakhs. They met a first payment of 15 lakhs. And the
Okay.
rest of the payment to be met within 4 months or so. Yeah.
So whether the
That
rest
was-
of the payment made?
Yes, Lordship. And to that effect, the complainant has made a declaration. It is at page 27, Annexure D.
Page 27.
Yes, Lordship.
Okay. So the informant
Yes,
has made a
Lordship.
declaration.
Yes, Lordship, that he has
What he
received all
declared?
payment. He has received all due payment. May I read, Lordship?
Yes, please.
I, Aheto Jimomi, son of Bihoshi Jimomi, resident of Taheke village, Dimapur, Nagaland, do hereby solemnly affirm on oath and state as under that I am the complainant in GR case number 583 of 2023, corresponding to Suburban Police Station, Dimapur, case number 48 of 23 under section 409 and 420.
Okay, next.
That on 0809
An agreement was entered.
Yeah, that agreement
executed.
with the family members of Muhammad Khalid Hanan with the conditions that the guarantor number 1, who is the wife of the accused, shall pay the amount of the remaining rupees 37,09,550 only in 3 installments mentioned in the agreement dated at 09/23, registered number 4225/23, dated 09/09/23 at Notary Dimapur. that as per the terms and conditions of the agreement mentioned above, I have received the entire amount from and on
Okay.
behalf of Muhammad Khalid Hanan.
Okay.
The final installment is received on
So
10
what happened
1.
after that? Whether you approached the trial court?
Yes, but it was already charge sheeted.
No, already charge sheeted. Thereafter, have you approached? No.
Actually, Lordship, one of the section is non-compoundable.
Which one?
409.
409.
Yes, Lordship.
Okay, so you're approaching this court. And whether the respondent has filed any affidavit? You are for respondent.
Yes, Your Lordship.
Informant.
Informing Your Lordship.
Okay, file affidavit.
Yes, Your Lordship.
What is your contention in the affidavit?
No, please, Your Lordship. Lordship, I have no objection to the prayer led by the petitioner.
Since you have received
Since
all.
I have received all the claim,
Okay.
Your Lordship. I no longer want to, I no longer wish to pursue the case, Your Lordship.
Okay. Affidavit, it's all the same. Right to Jimmy, to Jimmy. So the state.
May I please, Lordship?
Yes.
My lord, since the case is civil in nature
Hmm.
and already
Right.
settled and the agreement also entered, so I have no objection.
That's fair submission. Okay, so we have hardly time. So there are other methods also. We'll dictate it tomorrow. I'll keep it as CAB if it is possible. If it is done, tomorrow we'll deliver. Okay, it may not be possible because there are other method, morning method also.
Okay.
It will not be possible for tomorrow, but then if it's still, even if I carry it also, I'll deliver from the Itanagar or from the Gauhati. Okay, hard. Wait, not yet. Hard. Miss
Aslında Longkumar.
Asenla
Longkumar.
Longkumar, Line Counsel for the petitioner. So. I've also heard Mr. Tibapong. Learned senior, sorry, learned PP for the state of Nagaland. And Miss
원찬호 훈절.
Wangcha,
원찬호 훈절.
okay. It's Wangcha,
원찬호.
Wanchalo. Okay. Wangcha. No, because Wangcha is.
The last page, man.
Oh, yes, sir. Wangchano. Appearing on behalf of the respondent informant. Respondent number 2 informant. Okay. Hearing concluded. Judgment reserved. Okay.
Much obliged, Lordship.